drip, yeah, I know she can't hold it. Yeah, I know your bitch even though she got COVID.
YallTough.com right now and get you that new Sniper Gang merch. Use promo code Showface News to get 15% off on your order right now. And also make sure you follow Showface News on Clubhouse right now to be a part of the conversation. Join the Sniper Gang today. Salute. Personal client of mine who followed all my methods, and look where they at right now. This only took 2 days. This was only 2 days. This ain't take too long. This took dedication. This took hard work. He used YouTube Shorts. What are YouTube Shorts anyway? YouTube Shorts are in a battle with TikTok right now, trying to be the best at this whole quick video thing, you know what I mean? So the competition level is crazy. YouTube versus TikTok is going on right now. So the number one thing being viewed right now on YouTube is these quick YouTube Shorts. But how do you get in this algorithm of YouTube Shorts to be getting views like this? 306.5K views in 2 days. I'm telling you, my methods work. If you're serious about this YouTube thing, just DM me. Let's get you right today.
Picture of things to take into consideration with the other things presented, as well as the Ayala factors, Your Honor. There was a lot of proffers about the murder count that Mr. Farley is alleged to be a party to.
Welcome to Showface News, y'all. Make sure
the warrant affidavit
like
itself
button.
alleges no party to a crime allegation whatsoever. It alleges just mere presence and mere association, Judge. And I've now done a little investigation into Mr. Farley's clothing company,
this is the
which is what brought him into all this in the first place, Judge. And so I do want the court to consider that together with some proffers. And I understand the state's position about the privacy of the discovery, and that they have a pending motion about us not sharing discovery outside of our legal staff. And I would also, for the record, they have made some implications about the defense counsels in this case. Yet they're using Dropbox, which is a private third-party company. So it's entirely possible that someone within their office or someone within Dropbox has connections to social media and TMZ and stuff like that. So I would ask, Judge, if we could do an in-camera inspection of some very small portions of the discovery, specifically the BP video that the state referenced earlier at the prior bond hearing.
Did you put that in your motion?
No, Judge, I didn't.
Okay, so I'm going to take up that on the 8th. So if you want to proffer or have me consider that, file a motion. I'd invite you to put some suitable facts and law in there like you're doing right now, and have me consider it and have the state respond to it, okay?
Yes, Judge, and may I continue?
Yes, you may. Go ahead.
Yeah, so in the case that bond is denied today, Judge, I will return on the 8th with that in-camera motion. But for now, Judge, I'll proffer what I find different to the state, Judge. For one, the state implied at the prior hearing that Mr. Farley knew these people very intimately, that he greeted them when they walked into the BP. But, Your Honor, what actually happened is there's a Fusion and an Audi. The Audi is alleged to have Mr. Shannon Stillwell in it. The Fusion is alleged to have Mr. Quamarvius Nichols and Mr. Farley in the back seat with Quamarvius driving. And so the Audi and the Fusion are at this gas station right around from the juvenile court, Your Honor. And then the deceased pulls up in a car. And when that deceased leaves, the Audi follows him and the Fusion follows him with Miles in the back seat of the Fusion. The license plate readers confirm that the Audi is in front of the car that Mr. Miles Farley is in the back seat of. And Your Honor, it's this mere association with Mr. Quamarvius that led him to be there. He's not even a driver of one of the cars. And he doesn't actually greet anyone when he walks into the BP. Mr. Stillwell and Mr. Nichols are standing at the cashier, doing something playful with the cashier. And Mr. Farley later gets out of his car from the back seat, walks into the store by himself, and doesn't acknowledge Mr. Stillwell or Mr. Nichols. And as he's walking by to get something, Mr. Stillwell turns and does this playful, bucking kind of playful thing and startles Mr. Farley, who then playfully turns around and continues to go into the store. And then out of the corner of Mr. Farley's eye, he sees Mr. Stillwell and Mr. Nichols about to just leave him there. And so he, in a panic, scurries away, follows them out the door. They don't even acknowledge him any further. They turn his back on him and they leave. Your Honor. So the association and the presence here has more nuance to it than the state alleged at their proffer, Judge. And so what I contend to this court is it's corroboration of what I presented to the court initially, that Mr. Farley, he's a graduate of South Atlanta High School and Miles University, and all this time at 24 years old, has never been convicted of anything besides a misdemeanor amount of marijuana at some point, Judge, which is a typical teenager childish thing. So, Your Honor, he has no criminal history. He's an entrepreneur with a business degree, and his specialty is he makes clothing. The company is called Make America Slime Again. It's a play on words. Hip hop industry, there's a lot of this. You put the word trap or slime into something that's already part of pop culture. It's just good business, Judge. It's something people already recognize. It's something that's kind of humorous. And this is one of the shirts, Judge, I have for you to see. This was a new shirt after Make America Slime Again off of the Trump logo or slogan. Now there was Keep America Slime. So all it is, Judge, is these hats and shirts that took the Trump merchandise, replaced it with this word slime, which is not always criminal. And like every word, and especially that word, it's context dependent. It's like the word dude. It depends who's saying it, when are they saying it, who are they saying it to, why. You could be my dude, you could step on my shoes, and I could be like, dude, what was that? You could be that dude. There's so many things. So slime on its own means nothing because it can mean so many things depending on the context. So that's all he's doing, Judge. He's making these clothes. He sees a business opportunity. He's friends with Mr. Wunny Lee, who's the creator of the hip hop persona Slime Life Shorty. And as his friend, he becomes his personal assistant to make sure he gets to music videos on time, stuff like that. He's actually paid by the label that's not even YSL. And then, Judge, he's using the proximity to celebrity to take advantage of just attention, which is a top commodity these days, name recognition, product placement, to have his hoodies and his shirts in these music videos worn by these artists is a way to make money. And he's born and actually raised on Cleveland. It's not just a tattoo. He's raised on Cleveland Avenue. His dad's also an entrepreneur. They call that area Little Haiti because there's not a lot around, so you have to be an entrepreneur. So here we have a young man, college educated, never been arrested for a felony, and he's making his clothes. And instead of sitting there and maybe, selling them on the street next to the people, doing the lamb chops or selling the Powerades, he has this brilliant idea to go on tour with Mr. Wunny Lee and sell to like fish in a barrel, these suburban kids that go to these concerts. And I can proffer, Judge, as an officer to the court, I remember what that environment was like, back in 2008. Going to University of Michigan, go to the Kid Cudi concert, buy the t-shirt. And I almost want to say that I do remember there was a shirt where they had Kid Cudi as the Obama campaign thing at the time. So similar to what's going on here, Judge. It's like a deja vu. And so I admire Mr. Farley. He's very smart. He's well educated, and he found an opportunity to
the worst offense
make
in the world.
this clothing.
You said it's
And
not
then the
always
state, because
criminal.
he's wearing this shirt that says slime or die.
You made him look
Again,
criminal,
play on
nigga.
words. If Your Honor remembers
always criminal.
the Get Out the Vote campaign, vote or
This is
die.
the worst
I
offender.
think it might have been
They
P.
couldn't
Diddy or
die.
some people at the time were pushing that. Again, Judge, just artistic play on words, proximity to other artists who are in music instead of clothing. And that's all this is, Judge. So on the Ayala factors, he hasn't ever threatened to tamper with any witnesses whatsoever. He's barely in any of the discovery. This 5 terabytes, it's not even everything, but he's barely in it, Judge. He pops up on the scene because he returns home after going to college instead of going out of state. And, I admire him for that. He's a family-oriented person. He has a child. The mother of his child helps him with the clothing company, Your Honor. And his father still stays there in the barbershop on Cleveland Avenue. And so I just don't see now, with having the discovery and knowing more about the clothing line, how we can deny Mr. Farley's bond. He can't be considered any risk, let alone a significant risk of reoffending, because he's never even been accused of a felony besides this. And the warrant affidavit itself, to this day, along with the discovery, alleges no assistance or any of the other 5 ways that you can commit a party to a crime, in addition to being the principal. It does not say that. It just says that he was driven somewhere by Marvius, gets out of the back seat, gets back in the back seat, and then the car is behind a car that's alleged to be involved in a shooting. And we don't even know the circumstances of that shooting. It doesn't even seem planned. It doesn't seem to be connected to anyone the way the other murders are alleged to be connected, Judge. And so He can't be considered a significant risk to reoffend. He can't be considered a danger to the community. He's college educated with no criminal history. He can't be considered a flight risk. He's cooperative the entire time. He is arrested without incident, without flight, no attempts of flight. He's had his communications monitored this entire time. I know that the Fulton jail even has voice recognition that knows when people are using other people's phones. He's not anything like that either. And so, Your Honor, the state does allege that he's present at a public forum, a public hearing with Mr. Wani Lee at some point. But again, Judge, he's his personal assistant. And all that the discovery alleges is that Mr. Farley told him where the courtroom was. There's no threatening, there's no witness intimidation, Judge. His communication has been monitored this entire time at the jail, and he just can't be considered a risk for any of the IL factors. And so, Your Honor, we just asked for a bond to be set in a reasonable amount, given the severity of the charges, to add some harsh conditions. I propose for the court a bond of $100,000, that he stay at the address that we provided to the court at the prior hearing, 2894 Browns Mill Road in Atlanta, Georgia, zip code 30354. And that we put him under the highest pretrial level of supervision and a 24/7 house arrest, and even take away his internet access. He can conduct his business through assistance without having to actually access the internet himself, Judge. That way, there can't be any worry about him contacting any witnesses or anything like that. And so, Judge, I do want to call Miss Patricia Ford very briefly to say a few words about Miles. She's his high school principal. She knows him very intimately over several years, and she can speak as well to the IL factors, Your Honor. So I would want to briefly
hear how good he was, how much of a good child, and his grades were amazing.
All right, Ms. Ford, can you unmute yourself? Ms. Ford, can you unmute yourself, please?
Respectfully, the judge doesn't care.
Good afternoon.
Madam, can you hear me?
I'm just about to run down that address.
Yes, I can.
You're gonna have to speak up just a little bit. I'm gonna administer an oath to you, okay?
Okay, that's
Can you
fine.
raise your right hand for me, please? You solemnly swear or affirm the evidence you'll give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth. So help you God or so affirm?
Yes, I do.
Okay, you can put your hand down and you have to speak up. Use your outside voice.
So my name is Patricia Ford. I was Miles' principal for 4 years. Miles, he was my student. He was like my son. Everyone knew Miles was my student. And if Miles didn't do his homework or he just didn't do anything on task academically, they would bring Miles to me and I would just address Miles like he was my child. Everyone knows the love that I have for Miles. He performed well academically. He's a short kid by stature, but just a mighty soul and a mighty person. A lovable young man who went off to do great things after leaving South Atlanta High School. And so as a school, we all know Miles, we love Miles, and have just been taken aback by what he's being accused of just because of his disposition and demeanor that he portrayed and demonstrated while at South Atlanta. Never got into any trouble while at South Atlanta. He may have gotten into something his senior year for horse playing. He is known for just being a jokester and horse playing at school, but getting into fights never happened at South Atlanta High School. Not in my 4 years of knowing him. Just an overall good kid.
All right, thank you, ma'am. And just to be clear, you were the principal. Was Miles ever accused of any kind of misconduct or suspended from school or anything like that besides the horseplay that you mentioned?
Nope, not at all.
Okay. And did you stay in touch with Miles after you graduated?
Yes, we did. He would come by the school when he was on vacation from school. He would always talk to another staff member at school, and I would keep up with him through her.
Okay, and as a principal, do you sometimes have a sense when you're observing these students in their formative years, which students might get into trouble in the future and which you feel like, no way, that's gonna happen? And which of those buckets did Mr. Miles Farley fall into? Your discretion as a principal?
This would be the one that would never get in trouble because of his home bringing by his parents. He was just like a good kid, like we would say, just raised the right way. So just knowing that he's caught up in this is just taking many of us aback at the school who are still there and who knows Miles.
All right, thank you, ma'am. And then if he requires any of your assistance while he's being supervised and released on bond, would you be there for him to support?
Absolutely.
All right, thank you, Ms. Ford.
By
Those are
the
all my
way,
questions.
guys, they're not speaking on
Do you
Gunna
have
as
any
thug yet.
questions of Ms.
This
Ford?
is another YSL member. This is another YSL member they doing right now. They did not even get to Gunna or
Okay,
Young Thug
Ms.
yet.
Ford, thank you very much. I'm gonna put you back on mute. You can be excused to go back to your usual duties and avocation. Okay?
Thank you.
All right, thank you much, ma'am.
Miles is a YSL member. I don't know what his rap name is, but he's
Your Honor, that's all I
YSL.
have at this time, except for a brief opportunity to respond to anything that the state might say.
Okay, what says the state? Go ahead, Mr. Geary.
I'll just do it from here.
You can sit or stand, sir, whatever your pleasure. I know we've been here a while. It's about time for me to take a break, so.
No problem, Judge. Judge, contrary to what counsel just indicated, there is actually nothing new from the bond hearing from the 20.
We almost got 300 people in the room. I'm gonna need y'all to get them likes up respectfully. Make sure y'all smashing that like button. Let's get these likes up because the likes help the channel. Also, feel free to send donations.
We
got all types of donation options in the live chat. So feel free to hit the donations.
Mr. Farley instructed his girlfriend and or baby mother to dispose of a phone and dispose of a gun before we could get there. She didn't. We got it. So that's there. We've got Instagram posts by Mr. Farley basically saying forever homicide. Now, that's not a closing. That's in line with YSL gang, with other gang members. He's got the tattoos. He can't hang around YSLs and falsely claim. He's got them, the tattoos, and he's hanging with other YSL members. So he's not falsely represented. He's in the video. He wants to say he's Mr. Lee's assistant. He's in the video throwing gang signs, armed with a weapon. I'm not sure if that's in his job description as an assistant. He is seen numerous times on Cleveland. They say he's raised on Cleveland. Raised on Cleveland is the name of the predecessor gang to YSL. That is a street gang. If people want to just say, oh, I was raised on Cleveland, that's a gang identifier, Judge. Slime about, he wouldn't be the first criminal to try to make $1. Judge, the fact that he might have a clothing line on theirs, and I will say that for Mr. Williams also. Mr. Williams has made an interview that stated the gang pre-existed the record label. It pre-existed the clothing line. That's recorded statement by him. So anything that's marketing after that is an opportunity. I'm not saying they're not taking advantage of that. That doesn't mean they're not committing the original crimes. So just the fact that he is trying to make money off of selling something that is gang related, that has got nothing to do whether he would commit an offense. And I say this kind of left-handed respectfully. I know counsel didn't make an admission here, but he states the recording does show he's there on the scene at the time of the murder. It does. And it shows a lot more than that, Judge. He characterized the recordings. It's going to be for the jury to determine that. Judge, this is basically the same thing was presented to you on 523. You found that there's no reason, there's no evidence presented to change that ruling, Judge. Yes, or no.
Okay, all right.
Yes, Your Honor.
You got a minute?
Yes, just a minute, Judge. I agree with a lot of what the state said. Yeah, making a clothing line and using artistic content doesn't connect you to crime and make you a criminal. Just like wearing a Scarface shirt or a Godfather shirt doesn't make you part of the mafia. It's art. What Mr. Williams is making is art. It's spread all over the world. And now Mr. Farley is a bystander, Judge. What the state didn't correct was that, yeah, he's on the BP video, not doing the things that the state proffered he was doing at the original bond hearing, Your Honor. We didn't have any of the discovery at that time. And this hashtag YSL, I mean, the word slime isn't even originated in Atlanta, Your Honor, as far as I know. I went around on the internet a little bit. There's a mixtape by VOD up in New York in 2009. It's called Slime Flu 2. And that predates a lot of this. So I think they're trying to just take advantage of this cultural term. Again, slime or die, it's just a play on words from vote or die, Your Honor. And it has nothing to do with whether or not someone's committed a crime. That's done through evidence. And the state still has not proffered anything beyond mere presence and mere association. The Forever Homicide, Your Honor, that's a song by Mr. Wani Lee, performed by the character Slime Life Shorty, where it's a play on words of homicide and homicide. I'm always by my homie's side. And it's just a little play on words with the word homicide. Mr. Farley, you heard from his principal, has never even been violent at school. Gang behavior begins sometimes at 12 years old, 13 years old. This is so out of the ordinary as an allegation. Who joins a gang when they're 24 years old and never even got in a fight at school, and yet they're a homicidal person that can't even get a bond when they're presumed innocent? So, Your Honor, this YSL has been hashtagged over 21 million times all time in Instagram. And so because Mr. Farley has a page that also has T.I. and Future on it, wearing his hats in addition to Mr. Williams, it's just not, there's still nothing now that we have the discovery. And now we also have an actual live witness, Ms. Ford, to correct the misstatements of the state in the prior bond hearing. And it's clear now that Mr. Farley is not a significant risk in any of the IL factors. And there are ways to mitigate these baseless allegations of witness tampering that he has nothing to do with and has been reported all this time. And if they have his phones and they have these incriminating things, and yet that's all they can still proffer, Your Honor, he definitely deserves a bond. It's just the conditions are at issue now, and we're willing to submit to any conditions from this court whatsoever, Your Honor.
All right, thank you, sir. All right, Mr. Menendez and Mr. Geary and Mr. Farley. I've had an opportunity to reconsider the what has been proffered in this particular from the 523 hearing in this case. Mr. Menendez, I don't find any change in circumstances. I do agree with the state in this particular situation. At a minimum, your client still poses a threat to persons and property in the community and poses a threat to intimidate witnesses or otherwise obstruct administration of justice. So I'm going to deny bond at this point in time. He's still on trial for the 9th of January of 2023. And if you file any other motions, let me know and we'll go ahead and hear those expeditiously, okay?
All right, thank you, Your Honor. Good to see you.
Can we arraign since we've got counsel?
Yes, Mr. Farley and Mr. Menendez, since you are here and the new indictment has in fact come out, Mr. Menendez, would you like to go ahead and have me arraign your client on the re-indictment?
Yes, Your Honor, that's fine. I went ahead and filed a packet of consolidated motions.
Okay.
And all I can think of now is that in light of the bond denial, I do intend to join in Mr. Steele's speedy trial motion.
We'll file it and we will move on it accordingly. But in terms of the indictment, 22 SC 183572, is it your desire to waive formal arraignment on behalf of your client?
Yes, Your
Otherwise,
Honor.
have the court enter a not guilty plea on behalf of your client, and for you to have at least 10 days upon the receipt of discovery to file any motions.
Yes, Judge, we waive formal arraignment, plead not guilty, and we would ask that in light of the massive amount of discovery and the several co-defendants that we be allowed 60 days till after the completion of discovery to particularize or file any.
I'll give you 30.
Okay.
Because I'm still planning on moving on this case on the 9th of January. So, and I believe you've been given some discovery already, correct? So this would just be updated discovery. They just re-indicted to, for other reasons, but I'll give you 30 additional days, okay?
All right, thank you, Judge.
All right. Then, and then it'll remain on the 9 January 2023 calendar, okay?
Understood.
All right, thank you very much, sir.
All right, I'll see you on the 8th.
All right, okay. All right, Mr. Farley, you can be excused at this point in time, sir. Thank you. No, unless he has any other motions that have been filed, no.
Okay. I'll let the court know, Your Honor. I do anticipate filing a motion to sever, but I'll just keep the court updated with.
If you file such motion, let Mr. Chamberlain know, and I'll make a decision as to whether or not I hear on the 8th or some other date. Okay?
Yes, sir. Thank you.
All right. Thank you, sir.
Make sure y'all get them likes, but man, we got 500 plus people. We gotta get them likes up respectfully, you dig?
All right, let's see who else we have
Anybody
left.
coming here disrespecting the channel, you will catch that boom. I ain't even gonna hold you.
At least proffer
You
at
can
this
watch
point
from
in
the
time.
stands,
I
champ.
believe that we have, let's see. Miss Omana, can you tell me who's in N506?
One moment, Your Honor.
Thank you, madam.
Your Honor, Mr. Garland and I both have an afternoon conflict. If we could do our work whenever the court's ready for Mr. Kitchens, that would be helpful.
Madam, I'll go ahead and take that up next, okay?
Thank you, Your Honor. I think he's already on the Zoom.
He is. He is.
Your Honor.
Just hang tight, hang tight. And folks, Ms. Nova, Nova, I understand you're eager, but I need to take a comfort break. I've been here since the time we came out, and I'm over 50.
Of course.
And so is Mr. Apt and several other people, Mr. Gary. We would all like to take comfort for just a few minutes. So if we could maybe have 10 minutes, that would be great. I think that would probably be appropriate under the circumstances. So I'm going to take 10 minutes. We'll see who's here at that point in time. I'll go ahead and take Mr. Kitchens up at that point, okay?
That nigga Thug looking like he back in 2014 again.
You can be excused, thank you.
Oh man. Hey, make sure y'all getting them likes up respectfully though, you dig? Get the likes up. Feel free to donate. Let me tell you something. If you come on my page talking about, oh, I'm not donating, I'm just gonna watch, like you're gonna get boomed. Because if you don't want to donate, you don't have to. You're not obligated to. It's for the people who do want to donate. If you come in here acting like, oh, donate, why would I do that, nigga? I'm gonna boom you, you broke bastard. You're gonna get boomed for being a broke bastard, respectfully. I ain't gonna hold you. Go to wearetough.com to copy your reflect tees, your sniper gang tees, and etc. And don't come in here showing your ass though, because I will boom you. You feel me? Don't come in here wilding. You dig? Respect the channel, respect the platform. But I don't know what's going on today. I have a feeling nobody's making bond though, respectfully. Phone hearing.
I got an adapter. You can plug in. If you've got the cable, I got it down here. Hey, Juan.
Good.
Hopefully that works.
Good. You lost a little bit of Atlanta. Wow, 199. Yeah.
Sergio, your audio still is on, by the way.
All right. And Jeffrey, I don't believe you're muted either. You're not muted.
These niggas not coming out, y'all. I want y'all to understand that, man. This a RICO case. Niggas ain't making it out of this. I'm sorry to tell you. You know what I'm saying? Niggas can't make it out that RICO. That RICO different, champ. I mean, and they just took a 10-minute break, just so y'all know. They took a 10-minute break. They be back. They just took a 10-minute break just now. There's a YSL member named Slato who they was just speaking on. One of the YSL members by the name of Slato was just up there. I'm saying, but they coming back in though.
Got it.
Don't talk. Don't even talk to each other. Sergio, not you. Just don't say anything. Sergio, I'll try to come see you tomorrow, or at least do a call tomorrow, okay?
They got Kevin Lyles. This nigga Kevin Lyles is in the whip right now. You got this nigga Kevin Lyles. This nigga Kevin Lyles in a whole Uber right now on the joint, my nigga. This shit crazy. Oh man. That trial gonna be very nasty. I'm gonna keep it real with you. That trial is gonna be very nasty, ladies and gentlemen. Respectfully. That trial is gonna be very nasty. I ain't gonna hold you, gang. Hey, I tell y'all this right now. So if YSL beat this Rico, just know the Illuminati is very real. If you thought it was fake, it's not fake. If these niggas beat this shit, the Illuminati is real. I will become an Illuminati YouTuber. I promise. I'm gonna be breaking down numbers. You know what I'm saying? I'm gonna be on my Gematria shit. As soon as I find out that if these niggas are free in January, I promise you, I'm gonna be an Illuminati. I'm gonna be one of them weirdo Illuminati YouTube niggas. Real talk. I swear to God. Yeah. Listen, man. There's no way in hell. How many niggas you beat the Rico, nigga? How many niggas you know beat the goddamn Rico? Nigga, only Illuminati can make it happen, nigga. I'm gonna become one of these weirdo Illuminati niggas.
Everything you say out of context, so I don't, even if you say to my family, maybe some gangs like, talk about later.
Nah, it was about a visit with you.
Huh?
It was about a visit with you.
Oh, okay. Let me I'll do a video call with our house.
Yeah, I was telling them to reschedule it. Okay.
Okay. Can you see me now?
Yeah, I can see you. I was telling you just tell my family to rebook the visit behind.
Okay, all right.
Hey, listen, all Ricos is not successful. But however, if you in it, you in it. This is different, champ. Hey, somebody got Frank in their gippers. I'm gonna let you take time. You don't tell me what to do on my channel. They can say I didn't come here for your comment. Hey, listen. I'm sure you didn't plan on coming in your grandmother's crib and seeing her with Frank in her throat neither, nigga. Did you? Did you come home to your grandmother's crib and expect her to have Frank in her tonsils? I didn't think you did, champ. You're gonna have to take time. Get out of your grandmother's crib, champ. How about you get out your grandmother's crib, champ, respectfully? She's tired of you taking up space. You invaded her privacy, nigga. Go take time. She's tired of you disrupting her while she gobbling Frank, nigga. You might have to take time, respectfully. Come on, man. I dare nigga to tell me what to do on my channel, nigga. Your grandmother said to hold her wig while she's giving another man throat, champ. That's what your grandmother said. Your niggas gonna have to take time, respectfully. Nigga said nobody asked for your commentary. Bitch ass nigga, we are on a fucking break, a 10-minute break, and nigga said, we didn't ask for your comments. And nigga, eat Frank, nigga. Eat Frank. So get out your grandmother crib, nigga. You niggas is weird. Shit is nasty work. But make sure you get them likes up, man. Get them likes up. Smash that like button, man. Let's get these likes up respectfully. You are watching the motion hearing for Young Thug and Gunna. We on a 10-minute break. The 10 minutes probably turned into like 4 or 5 minutes now. But yeah, man. We on a 10-minute break. They just had a YSL Sletto before this even happened. We didn't even get to Thug and Gunna just yet, but we will. You know what I'm saying? We will, champs. You dig? We will, though. Listen, this is a serious case, bro, man. You talking about 50 bodies, man. You talking about 50 bodies. Listen, they not making it out. If they, like I already told y'all what I'm gonna do. If they make it out of this one, the Illuminati is incredibly real. You better believe the Illuminati is real. If you ain't believe it, then this is gonna be my my justification to believe that the Illuminati is real, because Thug, Gunna, and them made it out of Rico with undeniable proof. You feel me? Ain't no way, champ. Respectfully, salute to the chat, though. Salute to the chat as always. Smash the like button. You know what I'm saying? Follow me on TikTok. We won't say 10K on TikTok. Shit crazy. Boy, oh boy. This is crazy, y'all. Get these likes up. So we should be back. It should be back moving in a couple minutes. It took a 10-minute recess. They'll be back. You know, it took a 10-minute recess and all that. So this looking real bad. I did hear about Little Woody was the YSL snitch, but honestly, it's a 10-year case, so Little Woody must have been on it for 10 years then. It seems. Oh man. Let me get you up out of here too. You come in here on weirdo time, I'm gonna boom you. Go take time, champ. I don't even have my mods in here, and I don't need my mods. Salute to all my mods. Y'all probably not even in here yet. You know what I'm saying? But salute to my mods. They not in here yet because it's early. But listen, I'm a boom niggas, respectfully. You come in here wilding, talking that nonsense, you will catch that boom, respectfully. You dig? I know niggas be hating on us New York niggas a lot because y'all weird. Y'all got no swag. They be hating on the New York niggas because we got all the swag and all that. Stop hating, champ. People from all over the world fuck with Showface. Stop hating on the New York nigga. Killer, make the Frank love stop, champ. Respectfully. Whoa. You're gonna have to take time, nigga. What? Hey, champ. You don't just become a... See, here's the thing with Showface News Channel. You can't become a mod on my channel unless you are trusted. That's how it works, but you're gonna have to take time. I'm gonna keep it a G with you. You're gonna have to take time, my boy. I'm gonna give you that fresh 5 minutes. I'm gonna give you a fresh 5 to get right. You feel me? I'm gonna give you that fresh 5, let you get right. You dig? I'm gonna let you get right. You said something very crazy. I'm gonna hit you with a 5. If I hit a nigga with the permo fleck, that is what it is. If I hit a nigga with that premium reflection, it's over. He's going for good. He cannot come back. You know what I'm saying? You're gonna be sitting Indian style till your knees break. I'm buying viewers. Yo, he said I'm buying viewers. Yo, you see how they be hating on me? He said I'm buying viewers. Why you mad? You mad? Look at you, champ. I'm buying viewers. Oh, check his social blade. You funny. You're funny, bro. Salute to you though, champ. I love the hate. You know what I'm saying? I got it from the ground up. Niggas know. Niggas mad they ain't figured out the algae. You're mad. You're mad, champ. I love the hate though. I love to see another nigga accusing me. You know what I'm saying? I see another weirdo. Take time, champ, respectfully. You're going, champ. See you in another lifetime, respectfully. Niggas is mad that I'm talking on my own channel through a recess of a motion hearing. Y'all hear this? Niggas be so mad. You gotta love it. Listen, this YouTube shit come with hate, man. Prepare if you want to be big on YouTube and you want to get your name out here, niggas is gonna hate hard. You know what I'm saying? Niggas is gonna hate hard. Somebody said that I know I'm Illuminati. I might be Illuminati. I might be Illuminati, and if I am, so what? Mm-hmm. Shit crazy. Shit is crazy. Niggas be really mad. You gotta love it though. You gotta love the hate. Yeah, man. The hate is real. That's YouTube. That's social media. Hate. People have embraced the hate. Being hate is cool. You know what I'm saying? Somebody said Whack 100 is using my lingo. I mean, look, Whack watches my channel. I've called Whack. If you've been here, I've called Whack. Whack is a clown. And also tell Whack if I see that nigga in person, it's up. Whack ain't get hit. Apparently, allegedly, Whack ain't get hands put on him enough. So if Showface put hands on him, don't be surprised. Tell Whack that you heard me say it. Tell Whack that you heard me say that if Showface see him, it's up. I will allegedly put hands on that 5'7" biscuit head nigga. You understand me? I'm not playing with these niggas, man. Tell him I said that. He's gonna get violated again. I'm not playing with niggas, bro. You feel me? Now you want to use my lingo. So when I see you, I see you. Respectfully. When I see you, I see you respectfully. Hold on, I'm about to boom you too. I'm about to boom you too. You look oppy, nigga. You out of here. You look very oppy, my nigga. Get out of here. Champ. You looking very oppy right now. You gotta go. Get out of here, champ. But y'all tell Whack, whoever's in here, you tell Whack what I said. I ain't playing with that nigga. When he see me, just know what's up respectfully. I'm not playing with not near nigga. And niggas take this YouTube shit for a joke if you want to, nigga. I'm not playing with niggas. I'm definitely a villain. Don't get it twisted. You know what I'm saying? Respectfully. I'm not playing with niggas. But niggas is coming in here looking real oppy, nigga. You got to go. You out of here. It is what it is. Comes with the YouTube thing. Comes with the YouTube thing. I got you, champ. Take time. Go back to work, champ. You shouldn't be here. This ain't a place for you, sir. Respectfully. You said there's no villains on YouTube. Okay. Okay, bro. Copy. You said nobody's a villain on YouTube. Okay. If that's what you believe, champ. There's villains everywhere. You know what I'm saying? Yeah, y'all. I'm not scared of whatever people you think he's involved with, because you don't know who I'm involved with, so you can't, you know what I'm saying? I don't care. Irv Gotti didn't get locked up. You know that, right? Irv and him ain't get locked up though. Everybody that gets so-called, hit with Rico, they wasn't getting locked up though, champ, respectfully. But you tell Wack what I said though. You tell Wack exactly what I said. How about that? You're right. They don't start their McDonald's shifts till lunchtime. That's a fact. Whoever works at McDonald's, congratulations. I hope you know how to flip a good burger, champ. I hope your burger flipping skills are elite. If you can't make that burger somersault with that spatula, you ain't a good worker, champ. Just so you know. If your patty flipping skills is not on par, just know you're getting fired tomorrow, champ. You're gonna have to take time. You should have made that burger do a somersault, nigga, but you didn't. You feel me? I'm just saying. You saw. Stop making soggy ass burgers at McDonald's, nigga. Stop making these soggy ass burgers at McDonald's, nigga. Respectfully, your burgers is mad soggy, nigga. You dig? Frank Love. You certified Frank Lover, man. You gotta go. Take time, champ. Respectfully. You came in here dabbling with Frank. You said I'm on a couch with cheap headphones. My headphones definitely cost over $100. Just so we're clear here. You're mad because you don't have a couch, champ. It's a lot of anger. I sense all the anger in the room. I see all the anger in the room. You're gonna have to take time, champ. You know what I'm saying? This is, by the way, this is a motion hearing, by the way. This is a motion hearing, by the way. You dig? This is a motion hearing. Hey, man, listen. Y'all gotta understand that right now online, hate runs the internet, man. You can't do nothing right. People hate on rich people. I mean, I can't say that people hate on broke people. They kind of cheer on the broke motherfuckers. You know what I'm saying? Broke motherfuckers get all the love. You're broke just like me, champ. I can identify with you. It's the people who's doing well that get all the hate. You know what I'm saying? It's the people that's doing well that get all the hate, champ. Everyone is, if niggas is not hating on you, you're not doing good. I'm not even deleting comments though. But listen, if they not hating, you're not doing good. So hate is always a good sign. You feel me? Hate is always a good sign. Just know that you can't out-troll me, and you're never going to out-troll me, champ. I'm funnier than you. You can't do, you just can't, champ. There is no, you can't beat me, champ. It's definitely an era of hating and trolling, bro. But when shit gets real, and if niggas come see you, is it gonna go too far? When niggas was trying to antagonize niggas, was it too far? That's all I'm saying. You feel me? Hey, listen, if they bring negativity to the table, it's for a reason. You feel me? That's what the haters do. It is what it is, man. But y'all seen Charleston White just get the ATL nigga locked up. You feel me? Charleston White just got the ATL rapper locked up. You know? Charleston White was jumping around his whole crib wilding, bro. There's definitely haters on YouTube. And salute to all the new subscribers too. Salute to y'all, man. Salute to all the new subscribers. We should be at 20K subscribers today. We should be at 20K subscribers today. So salute to everybody that's been supporting the channel as well. The supporters, even the non-supporters. Make sure you go to wearetough.com and get your Reflect tees, your Sniper Gang tees, and all that good stuff. We got everything on wearetough.com. Be sure to sign up to the Patreon, man. Be sure to sign up to the Patreon. All right, patreon.com/toughhouse1. This is where you can see all of our exclusive footage that cannot be on YouTube. Patreon.com/toughhouse1. Become a patron. It's very funny content. We have over 100 hours of comedic content that cannot be on YouTube. Some stuff you may have seen a little bit of, but we got everything here. Very exclusive. It cannot be on YouTube because it violates the community guidelines, allegedly. So become a patron today, y'all, respectfully. But what the fuck? Who's calling my phone? Is this scam likely? This is definitely scam likely. Stop calling my phone, champ. Salute to the new subs, though. Yeah, 10 minutes is seeming like 30 minutes, bro. Where's the judge? Did the judge have to, did the judge have diarrhea or something? I think the judge had a bad breakfast today, so maybe we gotta wait a little longer. You know what's on the judge. You feel me? You know what's on the judge. You know what's on the judge, champ. Man. Yeah, they taking a little long. Oh, you got a scam likely call too? Niggas is niggas hacking into niggas shit, finding out niggas numbers or something? Oh man. I got an iPhone and an Android. That's what you don't realize. I actually have two phones. I'm on my iPhone right now. I have an Android on my other side of the room right now. I got an Android and I got an iPhone. I like to have both. So I do have two phones, by the way. I do have two phones. I ain't gonna hold you. It's good to have both, in my opinion. You could do a lot. You could do a lot with a Android and you could do a lot with an iPhone. Oh man. Respectfully. Everybody getting their scam likely calls, apparently. Oh, Frank Love. You gotta take time, respectfully. Hey, listen, champ, respectfully. If you want to carve a heart into a Frank with a butter knife, that's on you. Do that shit elsewhere, not here, champ. This is a Frank-free zone, if you know what I mean. We don't do it. You know, all that stuff is strictly prohibited, man. If you want to carve a heart into a Frank like a tree on a picnic day, I don't want you to take time because this ain't that, champ. This ain't that. You keep that to yourself. You dig? Don't come in here with it. You want to carve hearts into Franks, champ. You got a very nasty, autistic mind, and I don't like it. Take time, respectfully. I'm sure there's a good place next to your grandmother's dryer where you can sit Indian style in that basement. And I believe the judge is back. So let's get right.
I have the video. I mean, not the video. I have the audio. That guy now. No, I don't have video. I just have audio from my thing. Because he just did like from 0 to 60. He didn't get tased though. Because my sister's a retired police officer. She's like, it's all high pitched. I said, yeah, he was just being interrupted.
Take time, champ.
Yes, you do. I got a lot of files. It's like, send it to a few people.
Please remain seated, court come to order.
Nigga, where the judge at? Where's the judge? Okay, there you go.
All right, I'm gonna take up Mr. Kitchen's at this point in time, folks, and we'll see who else is on the platform.
Uh-oh. It's up. It's on Gunna. It's on
Yes, you
Gunna.
may, of course, if you like. And I'll see you on the 8th. You got an in-court notice, and we'll send you out a also a formal notice as well, okay?
Thank you.
You're welcome, sir. Madam, hold on a second.
Got over 1,000 people in the chat. Make sure y'all get them up respectfully. Get them likes up.
All right, Ms. Novak, I have your client's waiver. I'm going to mark it as court 2. What were you going to tell me?
Actually, I think has something to add.
Yes, ma'am.
Your Honor, our position, because Mr. Winfrey is not in custody, and that's the only conflict we've identified with Mr. Sadow. Once we have, if Mr. Kitchens does decide to go ahead and waive that conflict, we would not have any further concerns about disqualification of Mr. Sadow beyond Mr. Kitchens' waiver, as Mr. Winfrey is not in custody.
Yeah, like I said, I'm not going to deal with Mr. Winfrey today because he's not represented. So, okay, that's fine. Ms. Novak, you still want me to go through the waiver with Mr. Kitchens?
I think we should.
I think we should as well, too. All right, Mr. Kitchens, let's see if we can unmute you. All right, sir, can you hear me?
Yes, Your Honor.
All right, sir, can I get you to raise your right hand for me, please? You solemnly swear or affirm the evidence you'll give in the case now and hearing to be the truth, whole truth, and nothing but the truth, so help you God, so affirm.
Your Honor.
One more time? Yes?
Yes.
Okay, you can put your hand down. Okay, Mr. Kitchens, I am holding a document which is entitled conflict waiver. Okay, I just want to go through that with you briefly, okay?
Yes, sir.
Okay, all right. It starts out with your name. It says, my name is Sergio Kitchens. I'm a defendant in Fulton County Superior Court, case number 22 SC 18227-3, which has been re-indicted under 22 SC 183-572. Did you have an opportunity to take a look at the both indictments, sir?
Yes, Your Honor.
Okay, all right. And this is a RICO case with 28 defendants, including Mr. Winfrey. We're not going to talk about Mr. Winfrey today, but you do understand that, correct?
Yes, Your Honor.
All right. You're represented by Mr. Sadow, Mr. Samuel, Mr. Garland, and Ms. Nove. Is that your understanding? Is that correct?
Yes, Your Honor.
Okay, all right. And it is your understanding that in late 2015, that Mr. Winfrey hired Mr. Sadow in Cobb County Superior Court case number 15-9-276528 to appeal his case to the Georgia Court of Appeals and then the Georgia Supreme Court. Is that your understanding?
Yes, Your Honor.
All right, and this is in the conflict waiver I'm holding up right here, and it bears your signature on the second page, and the witness is Ms. Nove. This is the document I'm reading from. So did you have an opportunity to take a look at this document and sign this document?
Yes, I did.
It would have been dated the 10th of June of this year. So I'm holding up the documents that's been submitted to the court. So that's the document I'm referring, okay? As court 2.
Yes, Your Honor.
Okay. All right. The Supreme Court reversed his conviction in Winfrey versus the state 304 Georgia 94. And that's further been cited at 816 Southeast 2nd 456 2018. And then Mr. Sadow then represented Mr. Winfrey in Cobb County, where his offered plea was entered. Is that your understanding?
Yes, Your Honor.
All right. It further goes on, your waiver further goes on to say that Mr. Sadow continued to represent you in this RICO case that's here in Fulton County after, and under the 2 indictment numbers that the court has already referenced. So you've spoken to Ms. Nove and discussed the types of potential conflicts that could come up with a lawyer who previously represents a defendant who later represents another defendant in a case in which both are co-defendants. So did you have an opportunity to speak with her to your satisfaction on that issue?
Yes, Your Honor.
Okay, all right. The waiver also further enumerates 6 points. The first one is the state could offer to dismiss the case against one defendant, reduce the charges, or agree to a lower punishment if that co-defendant would testify against the other. You understand that?
Yes, Your Honor.
You also understand, number 2, that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other.
Yes,
She talked with you about that, correct?
Yes.
All right, number 3, the lawyer may want to use a defense theory, witness, evidence, or argument that is helpful to the lawyer's current client but harmful to the lawyer's former client. You understand that?
Yes, Your Honor.
4, during closing argument, the lawyer may want to argue that the evidence against his current client is less than evidence against the former client. You understand that?
Yes, Your Honor.
All right. And then number 5, if there's sentencing, the lawyer may want to argue that his current client is less culpable than his former client. You understand that?
Yes, Your Honor.
And then number 6, the lawyer may have learned something from the former client that helps the current client but hurts the former client. You understand that?
Sir, I understand, Your Honor.
All right. So Ms. Nove went over examples of how these potential conflicts might come up in this case. Is that correct with you? Mr. Kitchens, are you there? I froze up, I think.
Nigga, shit frozen.
Oh, he's back. Okay. All right, Mr. Kitchens, what was the last, can you hear me?
Yeah.
What was the last thing you heard me say? I couldn't hear, I can't hear you, sir.
I didn't hear what you said.
All right, let me go over this last part here. The last thing I said was that Ms. Nove, did she go over examples of how these possible conflicts, the ones that I've enumerated in 1 through 6 on your waiver, might come up in this case? Did she talk about those, give you some examples?
Yes, Your Honor.
Okay, all right. Your waiver goes on to say that you understand these potential conflicts. Is that right?
Yes.
Okay. But you are certain that no actual conflict exists and that no actual conflict will ever exist.
Yes, Your Honor.
And that's your understanding. All right. Is that correct?
Yes, sir, that's correct.
All right. Do you fully understand what Ms. Nove explained to you?
Yes, Your Honor, I fully understand.
Okay. Do you understand you have the right to select a different lawyer?
Yes, Your Honor, I understand.
However, you don't want you don't want a different lawyer. Is that correct?
That's correct.
You want Mr. Sadow to fight for your innocence and freedom, is that right? That's what it says in the waiver. He's back. Okay, good. Well, okay. The last thing I said, sir, was you choose Mr. Sadow to fight for your innocence and freedom. Is that correct?
Yes, Your Honor, that's correct.
All right, and you waive any potential conflict and ask that the court preserve your right to choose the lawyer who you want to protect you. Is that correct?
Yes, that's correct, Your Honor.
And you make this statement voluntarily, knowingly, and freely in the presence of Ms. Nove. Is that correct?
That's correct, Your Honor.
All right, and you declare under the penalty of perjury that the foregoing waiver is true and correct. Is that right?
That nigga shit frozen.
Did you hear the last thing I said, Mr. Kitchens?
Heard declare.
You heard me? Okay, so you declare under the penalty of perjury that the foregoing waiver is true and correct. Correct? Is that right?
Correct, Your Honor.
Okay,
Yes.
all right. Do you offer this statement freely?
Yes.
Did anyone force, trick, or otherwise cajole you into entering this waiver?
That nigga either high or something. What's going on? Jesus Christ.
Yes, I heard you, Your Honor.
Let me go through this one more time. Do you offer this statement freely and voluntarily? No one otherwise forced or tricked you or in entering this waiver. Is that correct?
Yes, that's correct, Your Honor.
All right. Okay. All right. Anything else, Ms. Nove or Mr. Geary? I did already.
That boy about to testify, you heard?
Okay, no problem. No worry. Okay, anything else? Anything else is in terms of the waiver? Okay, all right. Any questions on behalf of the state or anything that you want me to inquire about?
Oh man.
Nothing from the state, Your Honor. We believe that satisfies any conflict from Mr. Sadow. And should Mr. Winfrey be captured, we would just ask the court to inquire of him at that time.
Yeah, I'll inquire about Mr. Winfrey when he becomes within the breast of the and jurisdiction of the court. Mr. Kitchens, I'm going to go ahead and let Mr. Sadow continue to represent you, understanding that in the future, if a conflict does arise, you are welcome to raise that to the court, or if I see it, I may raise it on my own motion or depending upon the circumstances in this case, okay? I think he's still frozen.
He said, he tried to say, okay.
They're not saying that he's actually snitching, y'all. They're not saying that he's actually snitching. Just so y'all know. Don't take that at face value what you hearing.
All right, Mr. Kitchens, did you hear the last thing?
Yes, Sean, I heard what you said. Thank you.
Okay, all right. Anything else in regards to Mr. Kitchens? Can we rearrange him? Okay, all right, okay. Mr. Garland, would you like to otherwise arraign your client on the new indictment, that being 22 SC 183572? Okay, I will authorize for you to waive formal arraignment. I'll enter a not guilty plea on behalf of your client. I'll otherwise give you 10 days upon the receipt of new discovery to file any other additional motions. Do you have any other issues, sir?
This is a motion hearing.
30. Okay, 30. All right, 30. Okay, all right, anything else? I got a mask on, thankfully. All right, okay, anything else? Do you have any other motions outstanding that need to be heard on the 8th of September, madam? Okay, all right, just want to make sure. All right, okay, all right. Unless you have anything else, then I will excuse Mr. Kitchens and excuse you all, councils, and thank you for your patience, okay? All right, okay, cool. All right. Do we have anybody else that's with us this, today that we can do waivers for at this point?
Your Honor, the call moment for Mr. Greer, he's going to agree on the motions contract. He is in N506.
Hold on 1 second.
Hey, this is a motion hearing. He's not snitching on nobody here, y'all. If he snitched, we're probably not gonna know about it. I'm just letting you know that. I do believe he's telling though, but still.
All right, Ms. Mormon, you like to have a bond hearing, is that correct? How come you can't do it now? I got space issues. That's why I'm trying to kind of do this, and it was supposed to be heard today. Okay. Yes, sir. Bond was filed. Again, motion for bond was filed on 6/28/22. Mr. Geary.
I don't expect you all to close the motion for bond. It's easy to get promoted last fall. He had a life sentence. He ain't going nowhere. Respect him.
He's not in on it. It's been reversed. He's out of line on that.
It's been. I'm again wrong. I'm closer to it.
Hey, you can't be right on everything, Mr. Geary. It's all right. It's okay. All right. So can we do his bond today? Okay. All right. Thank you, madam. All right. Okay, Mr. Greer. Ms. Amana, can we unmute N506, please, madam?
Yes, Your Honor.
Okay. Okay, Mr. Greer, can you hear me, sir? Okay, all right. All right, Ms. Mormon, if you'll go ahead and state what all the factors you wish the court to consider and any other relevant facts, I'll let the state respond and hopefully I'll make a decision, okay? All right, go right ahead.
In addressing the ALF factors, Mr. Greer is 33 years old. He's a lifelong resident of Fulton County. If released on bond, he will reside in Atlanta with his mother, and the significant amount of his family is here today. He has 3 grandchildren. His entire family is here from Georgia. When he was notified about the outstanding indictment for this case, he was on tour in California. He did immediately jump on his tour bus, come back to Atlanta, and turn himself in. He's not a flight risk whatsoever. As far as a risk to reoffend, he has no prior convictions. As the state has discussed, he was convicted in 2010 of murder. Since that conviction, he did take it up, it was reversed and remanded that time. He's been out on bond since 2019 for that. But outside of that, no prior convictions. The issue with the intimidation of the victims and witnesses, Mr. Greer is not accused of being in any gang. He doesn't have any tattoos. He hasn't been classified as being a gang member. He's not accused of any violent crimes in this indictment or prior to, aside from the non-reverse case. He's not been accused of any direct contact with any victims, any intimidation, having anybody else intimidated. The state offered that information earlier as well. This is a gang case, as you know, and not only that, there's 2 defendants on this case that are known worldwide with a magnitude of fans. So I don't believe Mr. Greer should be held accountable for any threats, alleged threats. Again, we haven't had any discovery or these allegations of threats. That's kind of out of his hands, whether he's in custody or outside of custody. Mr. Greer is not accused of intimidating or threatening any victims or witnesses in this case. And as far as danger to the community, again, he's not alleged to be gang affiliated. He has been out on bond since 2019. He had, as far as his time that he did serve in custody, he hasn't had a VR since 2013. He poses no threat. The time that he's been out, he's had no issues until this came up. He did have count, I think this count 13 in this case is the theft or receipt from firearm. He was arrested for that in 2020. It was no cross. He was charged with possession by a felon. He essentially wasn't a felon. That charge was no cross. Mr. Greer does meet all the factors in this case, and we understand that this case is set for trial in January. But given that he does meet all the factors, all four of the factors, we do ask that a reasonable bond is granted, and we are offering 24-hour home confinement at his mother's residence in Atlanta, and whatever other conditions the court is comfortable with ordering.
Okay. All right, thank you, madam. Yes, Mr. Geary?
A few things. I want to speak to you as part of the council statement is correct and threatened. He actually tried to set up their murder, and that is caught on wire at the jail. He was out on bond after that in 2019. During his stay in prison, he's a documented fellows gang member with extensive gang conduct in jail. He's part of a hybrid gang concept we've spoken to the court about. He's both a good fellow and he's YSL. He is also Mr. Williams' brother. He is on videos, throwing gang signs with weapons. He has the council told you the charges were dropped because he wasn't a convicted felon. But the other problem with that, he used his weapon was also stolen. So there's a theft by receiving charge, and that's what's count 13 in this judge. Judge, he is in leadership in that gang, and since he's been in there, Judge, there was not since he's been there, it's before he got arrested, Judge. We had him on a wire talking to people on a contraband cell phone about how to smuggle more cell phones and other illegitimate items into the jail through a window that had been broken. And that, along with an attempt to have someone in the jail murder an individual who threatened a fellow gang member in the jail by someone in the jail, that makes him not only a danger to the community, that actually makes him a danger within the jail. But Your Honor, he is a danger to commit additional felonies. He's a danger to the community. I can't say that he's a danger to flee. I don't know that to be true. But for the rest of them, I think he's a danger to intimidate witnesses, to the community, and to commit additional crimes, which he has done right up to the point when we arrested him on these charges.
You may now. You can talk.
Your Honor, the state proper information about Mr. Greer being a member of Goodfellas. I'm sure this has come up many times that typically anyone that is from a certain area of Atlanta, when they go down the road, they are identified as Goodfellas. In classifying him as being a Goodfellas, I don't believe that there was anything other than, I don't think there was anything that, aside from where he's located in Atlanta, that was why he was considered a Goodfellas. Also in being YSL, there's no identifiers other than Mr. Williams being his brother. There's no photos of him with YSL clothes. There's no tattoos. There's no, the state alleges gang signs. I haven't come across the gang signs that have been alleged yet. It's just a problem. As far as Mr. Greer being in a leadership position, the indictment states out very clear the members that they're accused of being in a leadership position, and Mr. Greer is not one of them. He's not charged in any gang counts in this indictment. And for those reasons, Your Honor, I do think he does meet all four of the factors, and I would ask the court to consider losing the bond.
Thank you, madam. All right, Ms. Mormon and Mr. Geary, the court's had an opportunity to consider the proffers for a bond in this particular circumstance. I do believe that he being Mr. Greer poses a risk of committing additional felonies. and he poses a risk of intimidation of witnesses or obstruction of justice, administration of justice. For those reasons, I'm going to deny him bond at this point in time.
Told you.
Ms. Mormon, if situation should change, you're welcome to file a motion for the court to change in circumstances or reconsider his bond. I certainly will do that. But at this point in time, I'm going to leave bond. I'm not going to grant bond at this point in time. And
Gunna was denied bond, y'all. Just
do we need to, let's see.
Need a waiver.
Mr.
Yeah.
Sergio Kitchens was denied bond,
I'm
y'all.
going to do that right now.
Yeah, champs.
So what's this? Tell me about that. There we go. Mr. Geary and Ms. Mormon, I am aware of that other case. It is a 10 SC case. I believe it's 10 SC 92020. So I will just put it, do you wish to go ahead and deal with that particular case? Can I, Ms. Mormon, would you like to waive arraignment on both those two cases, the 10 SC case as well as the indictment then under the new case, which is
22 SC.
the 22 SC
2573.
22 SC 183572. That's the new case, correct?
You inverted two numbers, 182573.
It's 183572. That's the re-indictment.
Yeah, the calendar has y'all are gonna have to probably correct. See, the clerk has written on the 22 SC 183572.
That's the re-indicted case. Yes.
Yeah, that's the re-indicted case. Okay, all right.
Okay, so the 10th case is the motion for new trial that Judge Newkirk granted. So the question for me is, do you want me to keep this case along with that case to deal with it, or put that to the first? What would you like with the 10 case?
You said the trial,
Yeah, we'll just put it in a trial posture, and put it on a trial calendar. In fact, it can go on that 9.
Because we need to keep account for the 10.
I'll put it on the 9 January 2023 calendar, madam, and I'll probably, unless we got one, and more than likely I will move it as I get my other trial dates come later this fall, okay? But just for accountability purposes, I'll continue. I'll go ahead and just lump that case with it. But as for the new indictment ending in 572, would you like to otherwise waive formal arraignment, have the court enter a not guilty plea on behalf of your client, otherwise have at least 30 days from the receipt of discovery to file any motions, madam? Okay, all right. I'm going to go ahead and put it on that 9/23, January 9th, 2023 calendar, okay? And and I'll also track the 10 SC 2020 case, but, or the 10 SC 92020 case. We'll put that on another calendar, okay? All right, thank you. All right. Mr. Greer, you can be excused at this point in time. Your attorney, Ms. Mormon, will talk with you a little bit later on, okay? Okay, oh, do we have a waiver issue with him? Okay, all right. Do you want to go ahead and take that up now?
Yes, please.
Okay, all right. What?
My calendar.
All right.
And make an additional inquiry, please.
You can.
You had mentioned earlier, and asking us to prepare an order. Ostensibly, I presume denying the state's motion to remove Mr. Steele as attorney for Mr. Williams. Because there are 4 individuals who are mentioned in the reason for conflict, and we've addressed one of them, about to address the second one, and the other one will not be addressed until at least the 8th. I would court hold off on drafting that order until that's all.
No, go ahead and do the order for the ones that we have for today. I'll enter a supplemental order when those 2 folks are taken up, okay?
Yes, sir. May I say something else also?
You can.
Earlier, the court made reference to, I thought I asked some questions, some clarifying questions in regards to our manner of proceeding, and I think I take some exception to the court's belief, assertion at that point that
This is, okay, since you brought it up, no, you may not at this point in time, because you interrupted me to begin with, okay?
Yeah.
We're here, Mr. Adams, here's the thing about it. You have to be patient with the court. You have to be patient with the court because I got a lot of freight I'm trying to manage. I'm always going to let you have and consider everything that you tell me and any motions that you file. But what you do is when you jump me, meaning that my procedure, or you jump in front of other people, then that it doesn't sit well. So I'm just going to tell you, if I offended you in any way, please take my apologies for it. It wasn't my intent to do so. I consider you to be a very fine attorney, and I've known you professionally for over 20 years. But having said that, I do get to control the method and manner of how things go in the courtroom.
I understand that. This is your courtroom, but I was asking a question to get some clarification, and I just feel like the court telling me to sit down or what I can do is take my seat was not appropriate. I treat the court always with deference, with respect. And the only thing that I ask is that the court treat me the same way.
I'm required to do that, Mr. Adams. We both are under the rules of professional responsibility. Okay? Anything else, sir?
That's all.
Okay, all right. Okay, who do we have at this point in time? Okay. Let me see if I can get Mr. Greer's waiver. Okay. Let me mark that as the next court exhibit in order. I want to say it's court 3. Is that correct, Ms. Weaver? Yes. Okay, all right. Okay, Mr. Greer, can I get, Ms. Amana, can you go ahead and unmute Mr. Greer, please? And the reason I muted him again for Cal folks is because there's a lot of background noise in the jail. So, yes. Okay, I think he's unmuted now. Mr. Greer, again, good afternoon, sir. Sir, I'm holding at this point, let me go ahead and swear you in at this point in time. Can I get you to raise your right hand for me, please? Do you solemnly swear or affirm that the evidence you'll give in the matter now in hearing should be the truth, the whole truth, and nothing but the truth, so help you God, so affirm? Yes, Your Honor. Put your hand down. Okay, all right. Sir, I'm in possession of a waiver for you. It's addressed from the law office of Lawrence J. Zimmerman, PC. And I believe it was dated or authored on the 20th of May of 2022. All right, did you have an opportunity to to read that particular document?
Yes, Ron.
Or before Mr. Zimmerman penned it, for you to discuss the things that we'll cover in regards to conflict?
Yes, Ron.
Okay, I'm gonna read it because it's very short. It just says, "Dear Brian, I've met with my client, Quantavious Greer, regarding any potential conflicts of interest." He met with you, is that correct?
Yes, Your Honor.
All right, that he being Mr. Zimmerman, right?
Yes, Your Honor.
All right, and he advised you of all the issues regarding your prior representation of him and your current representation of Mr. Jeffrey Williams. Is that correct?
Yes, Your Honor.
And then you discussed with Mr. Zimmerman all the issues regarding potential conflicts in this matter. Is that correct?
Yes, Your Honor.
Is that right?
Yes, Your Honor.
Okay, and that you are, he is insistent that you represent Mr. Williams, and he waives any conflicts of interest. Is that correct?
Yes, Your Honor.
And that it further says, I advised him that the court may ask him questions about these issues on the record. Is that correct?
Yes, Your Honor.
Did he tell you that?
Yes, Your Honor.
Let me just kind of ask you a couple other additional questions, okay? Because this is I just want to make sure that you understand what you're waiving at this point in time. Do you understand that the state could offer to dismiss the case against one co-defendant, reduce the charges, or otherwise agree to a lower punishment if that co-defendant would testify against the other?
Yes, Your Honor.
Do you also understand that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other? So it could be helpful to somebody else and be harmful against you. Do you understand that?
Yes, Your Honor.
Also, do you understand that the lawyer may want to use a defense theory, witness evidence, or argument that's helpful to the lawyer's current client, and that would be Mr. Williams, and harmful to you? You understand that?
Yes, Your Honor.
During closing argument, the lawyer may want to argue the evidence against his current client is less than the evidence against the former client. You understand?
I understand, Your Honor.
All right. You also understand that if there's sentencing, the lawyer may want to argue that his current client is less culpable than his former client.
Yes, Your Honor.
Do you also understand that the lawyer may have learned something from the former client that helps the current client but hurts the former client?
I understand, Your Honor.
All right. Did you give this waiver freely and voluntarily? Means your own decision to enter a waiver this afternoon as to counsel, waiver of potential conflict of interest as to counsel.
Yes, Your Honor.
And you do so freely and voluntarily. It's your own decision. Nobody's forced or threatened or tricked you into doing so.
Yes, Your Honor.
Have you had an opportunity to speak, to fully consider this waiver
Yes, Your Honor.
and any potential conflicts of interest?
Yes, Your Honor.
All right. Any further inquiry you want to make, Mr. Adams?
No, sir.
All right. What about you, Mr. Geary or Ms. Rosenwasser?
I believe that satisfies the Your Honor.
Okay, and I've admitted that is number three, the letter from Mr. Zimmerman as Court Exhibit 3. Okay, anything else? Mr. Adams? Sir? Okay, all right. Can we go ahead and arraign Mr. Williams on the new charge or the new indictment?
Yes, sir.
Okay, all right. Do you want to go ahead and waive formal arraignment, otherwise have the court enter a not guilty plea, and otherwise have at least 30 days to file any motions on under the new indictment, that being 22 SC 183572, sir?
Your Honor, we waive formal arraignment. We do enter a plea of not guilty on the new indictment. We do ask for, the court had granted us previously. Previously, the court had given us 60 days from the receipt of all discovery to file particularized any motions. We ask for that at this time.
give you 30 days, and then the only reason why is because you all have started on the discovery process. I don't know whether or not, I suspect you've probably gotten some discovery, but I'm flexible with that. But let's go with 30 for the time being, okay? Okay.
And Judge,
Yes, sir.
of course, our waiver of arraignment and pleading not guilty is subject to the statements made previously by Mrs. Steele in regards to.
I will incorporate those and include those, and I believe that Mr. Geary owes an order in that respect, and we can incorporate that by reference, okay?
Thank you, Judge.
Okay, are there any other waivers that I need Mr. Adams, I need to take up in regards to Mr. Steele that are here today? I don't know if there are any, because
Yes, Your Honor.
yeah, Ed Adams is on, and as well as Ms. Merchant, and I think that they have, Martinez Arnold. Let me see if he's on. Is Mr. Arnold, are you on? Martinez Arnold? Are you Mr. Arnold?
Yes, Your Honor.
Okay, I guess he is there. All right. Okay, all right. Let me see if I have his waiver.
Y'all do know they not snitching, right?
Ms. Merchant and Mr. Adams, thank you for your patience with us today. I'm going to mark this one as court exhibit next in order, and that would be, I think, courts 4. Mr. Arnold, where are you, sir? Can I get you to raise your right hand for me, sir, if you wouldn't mind? Do you solemnly swear or affirm that the evidence you'll give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God, so affirm?
No.
I can put your hand down. Okay, all right. Mr. Arnold, just want to go through a couple things with you to begin with. Are you aware that Mr. Adams, on your behalf, penned, that is, authored a letter to Mr. Steele on the 19th of May, 2020?
Yes.
All right, are you familiar with the contents of that letter, sir?
Yes, Your Honor.
In terms of the waiver?
Yes.
Okay, I'm just going to go through it with you, and because it's 4 paragraphs, and I'll just read it and ask you some questions as we go along, okay?
All right.
Is that all right?
Yes, Your Honor.
Okay, all right. It says, Dear Brian, I am authorized to make statements herein on behalf of my client, Martinez Arnold. I represented Mr. Arnold in the state of Georgia versus Martinez Arnold, indictment 14 SC 131032, Fulton County Superior Court, which is a case involving a shooting at Lenox Mall. Is that the indictment that is referenced that he spoke with you about?
Yes, Your Honor.
Okay, all right. Mr. Arnold pled guilty to reckless conduct on or about February 18, 2015. That's correct?
Yes, Your Honor.
All right. I am aware of the state's motion to disqualify you, and that would be Mr. Steele, as counsel for Mr. Jeffrey Williams in the state of Georgia versus Mr. Jeffrey Williams et al. And that was under indictment 22 SC 182273. And that was the indictment at that point in time. Do you understand that?
Yes, Your Honor.
All right, do you understand the case has been re-indicted under 22 SC 183572? You understand that, right?
Yes, Your Honor.
Okay, all right. All right, and that is the matter in which Mr. Arnold, that would be you, as a co-defendant. You understand that?
Yes, Your Honor.
Okay, you have to speak up so I can hear you, okay?
Yes, Your Honor.
Okay, all right, thank you. The motion to disqualify is based in part on the allegation that you represented Mr. Arnold on matters relating to the 14 SC 131032 case. That's your understanding, correct?
Yes, Your
And
Honor.
Mr. Steele represented you in that case, and he's representing Mr. Williams in this matter. You understand that?
Yes, Your Honor.
Okay, all right. I spoke with Mr. Martinez Arnold This is Mr. Adams, okay. Regarding the state's motion to disqualify you as counsel, I explained to him what the state alleged with regard to you, specifically you, that Brian Steele represented Mr. Arnold on matters relating to the indictment we just mentioned, 14 SC 131032. I further explained to Mr. Arnold, that was you, the relevant law and ethical concerns at issue, and specifically that you're entitled to conflict-free counsel, and that you are representing Mr. Williams in this indictment, 22 SC 182273, which is now indictment 22 SC 183572, in which you're a co-defendant. You understand that, right?
Yes, Your Honor.
Okay. And he explained to you that you can object to Mr. Steele representing Mr. Williams.
Yes, Your Honor.
Okay, all right. And after providing the explanations that we just kind of went through, did you make it clear and unequivocal to Mr. Arnold Mr. Adams, that you never represented him relating to any shooting at Lenox Mall or any other matter?
Yes, Your Honor.
Okay, basically what Mr. Adams is saying is that Mr. Steele didn't represent you in any shooting at Lenox Mall. Is that what you understood?
That's correct.
Okay, all right. Or any other matter, correct?
That's correct.
Okay, all right, and that you explained that he believes that his friends contacted Mr. Steele shortly after the shooting to inquire whether there was an outstanding warrant for you. Is that correct? Say again?
That's correct, Your Honor.
Okay. And you insist that you never spoke with Mr. Steele about the case or any of the facts and the surrounding circumstances, correct?
That's correct. Correct, Your Honor.
All right. Let me ask you a couple of additional questions, just to make sure. Do you understand that the state could offer to dismiss the case against one of the co-defendants, reduce the charges, or otherwise agree to a lower punishment if that co-defendant would testify against the other?
Yes, Your Honor.
Do you also understand that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other?
Yes, Your Honor.
That the lawyer may wish to use a defense theory, witness, evidence, or argument that is helpful to the lawyer's current client but harmful to the lawyer's former client?
Yes, Your Honor.
During closing argument, the lawyer may want to argue that the evidence against his current client is less than the evidence against the former client.
Yes, Your Honor.
If there is a sentencing, the lawyer may want to argue that his current client is less culpable than his former client.
Yes, Your Honor.
And a lawyer may have learned something from the former client that helps the current client but hurts the former client.
Yes, Your Honor.
Do you intelligently, knowingly, and voluntarily waive any potential conflict of interest that would stem from any involvement you had with Mr. Steele and or indictment 14 SC 131032?
Yes, Your Honor.
All right. And you don't have any issue with Mr. Steele representing Mr. Williams?
Not at all, Your Honor.
Did anyone force, threaten, or trick you into entering this waiver?
Your Honor.
You offer this waiver freely and voluntarily, is that correct?
Yes, Your Honor. Correct.
All right. Mr. Adams, anything, sir?
No, sir, nothing.
Mr. Geary or Ms. Rosenweiss or anything?
Nothing for the state, Your Honor. We believe that satisfies any conflict with Mr. Arnold.
All right. And as I mentioned earlier, if any conflict should develop, please, notify all concerned at the earliest time possible. And the court will also, if I believe that there is a conflict, I will raise that issue and ask you all to address it. While I have Mr. Arnold here, let's see. Mr. Adams, or Ms. Merchant. Madam and sir, would you like to otherwise waive arraignment on the new indictment? Do you wish to be arraigned on that today? Or can we go ahead and do that?
We can waive arraignment on that, Judge, and we filed a couple motions on the old indictment, and then I filed a motion adopting all of those on the new indictment. And I think that would take maybe about 2 hours to be heard. We'd like to have our renewed bond motion heard with those motions. One is a motion to dismiss based on double jeopardy. One is a motion to dismiss based on a statute of limitations violation. And then one is a motion to sever. I think the sever could probably wait, but the other two dispositive motions would probably make sense to be heard at the same time as bond.
Okay. When did you file those, Ms. Merchant?
I filed them in late June, early July.
Okay. If you'd be so kind, you may have already. If you could send Mr. Kearns, my staff attorney, a copy of those as well. And I will take a look at those and we will determine if I can hear all of them on the 8th. I'll endeavor to do so, but as I mentioned, there's a lot going on. So I'll at least hear the bond. We can wait on the severance and I'll see if I can hear the other two at that point in time, because I would concur that they probably need to be heard up front, but more to follow on that, okay?
Great, thank you so much, Judge.
All right, I will go ahead and authorize you to waive formal arraignment, enter a not guilty plea on behalf of Mr. Arnold, and otherwise give you at least 30 days from the receipt of the new discovery or additional discovery to file any additional motions in this case. And we'll hear the motion for, I'll authorize the your motions that were filed in and under the prior indictment ending in 273 to carry over, and otherwise the state's going to file a motion in order for those, and I will adopt those, and I'll authorize your motions to carry forward into the new indictment ending in 572.
Great, thank you, Judge. And the date on that was the 7th of July. I just checked.
Okay. And that would be, and then I will, it'll be the 8th of September.
Okay, great.
For those motions, okay?
Wonderful, thank you so much, Judge.
All right, Mr. Adams, anything else, sir?
No, yeah, thank you.
All right, thank you all for your patience, really appreciate it today. Ms. Rosenwasser or Mr. Geary, anything else as it relates to Mr. Arnold? All right. Then I will release both of you counsels as well as Mr. Arnold, and we'll see y'all on the 8th of September, okay?
Great, look forward to it. Thank you, Judge.
Thank you, madam. Take care.
Take care.
Yes, ma'am, unless you have anything else. Mr. Greer, I think I've excused him already. And I've also excused Mr. Arnold. Yes, sir, you may be excused. Thank you, sir, thank you for your patience, okay?
Thank you.
All right. Okay, do we have any other waivers that we can address today, or any other people that I have not failed to address as of yet?
Just got it. On the second calendar, position 4 is waiver. He does not have an attorney. He's in DOC custody.
I don't think that we have dealt with him as of yet.
He does not have an attorney. He's in DOC custody to provide that.
He is not on the platform today, is that correct?
He will not be.
Okay, all right. We can set him for the 8th of September.
We'll need a waiver. Whether you want to waiver individuals as well as an arraignment.
We can do a waiver and arraignment if he's in fact, if he has in fact counsel. We don't know. I don't think he has counsel as of yet.
Not yet.
Your Honor?
Yes, who's talking?
Hi, my name is LaShondra Bishop. I'm here with Blaylock at Wilcox State Prison.
Wonderful, okay.
Your Honor, I believe my understanding is he was represented for the purposes of a waiver. I'm not sure if that attorney is here today, but we may be able to do it if that attorney is here. Mr. Lael?
Great Lael? Yeah, he's joining.
Okay.
I'm here.
Hold on, let me see if I have you right quick. All right, Mr. Lael, let me go ahead and, let's 1 second here. I'll put you. All right, do you see Mr. Blair? Mr. Blair, is there any way you can turn your camera on at Wilcox State Prison, madam? I can.
Yes,
see.
sir, give me 1 second.
Okay, wonderful. Thank you, madam.
Sorry. Okay. Can you see him now, sir?
No, ma'am, I just see Wilcox State Prison, that's all. Let me see if you're showing up any other place. I don't believe so. Let's see.
You still got a camera, I said at the top. Focal.
Okay, can you see him now, sir?
Yes, ma'am, I sure can. Thank you very much.
Okay. His last name is
Blaylock. That's my last name.
Blaylock. Yes, first name is Damon.
Mr. Law and Mr. Blaylock, thank you for your patience with us today, okay? I am in, Mr. Law, good afternoon, sir.
Hello, Judge. Thank you.
I'm in possession of a letter that was authored by you on the 31st of 2022. That's the one I'm going to refer to Mr. Blaylock and ask him some additional questions, okay?
Yeah, May 31st, Judge. That's correct.
All right. Mr. Blaylock, where are you, sir? Can I get you to raise your right hand for me, please, sir? Do you solemnly swear or affirm the evidence you shall give in the matter now in hearing should be the truth, the whole truth, and nothing but the truth, so help you God, or so affirm?
Yes, sir.
Okay, thank you very much. Mr. Blaylock, I'm going to ask you some questions. I'm holding a letter that I'm referencing that was authored by your attorney, Raymond B. Law, and that would have been on the 31st of May, 2020. Do you recall that having conversation about this letter?
Yes, sir.
Okay. I'm going to ask you a couple of questions about it. I know that you had a privileged conversation about it. I'm not going to ask you any specifics about that particular conversation, only the aspects of the representation involving Mr. Steele, okay?
Yes, sir.
Okay, all right. So the letter reads that he being Mr. Law is writing you pursuant to your conversation on Friday afternoon, May the 27th, 2022, concerning Brian Steele's representation of you on direct appeal from your convictions and sentences in Fulton County, as well as Mr. Steele's current representation of Mr. Williams in Fulton County indictment number 22 SC 182273, for which you are named as a co-defendant. Is that the conversation that you had?
Yes, sir.
Okay. Hold on 1 second, folks. I'm having a lot of chatter with somebody. Just see if there's anybody else. It's Mr. Lyles. I'm going to mute you.
Hello.
Hey, this chain.
We have some other people on the platform. I'm having to mute because, and that's why we're having some issues with, all right, I think I can hear now. All
A
right.
lot of y'all
Sorry
have
for
to
that,
take time
folks.
respectfully. You heard?
Okay. So, Mr. Blaylock, did you have a discussion with Mr. Law in regards to the issues the court just brought up? That would be the appeal of your convictions and sentences in Fulton County, as well as Mr. Steele's current representation of Mr. Williams in indictment 22 SC 182273?
Yes, sir.
Okay, and that particular case has also been re-indicted under 22 SC 183572. You understand that, correct?
Yes, sir.
All right. Did Mr. Law advise you as your independent counsel that you do not have to waive any issue regarding this potential conflict of interest and that you can object to Mr. Steele's representation of Mr. Williams if you desire?
Yes, sir.
Okay, I'm going to ask you another series of questions that were not in the letter that Mr. Law penned to you or discussed, but I want to make sure that he did in fact discuss these things with you, okay? To your satisfaction, all right? And
yes, sir.
I just want to make sure. Do you understand that the state could offer to dismiss the case against one co-defendant, reduce the charges, or otherwise agree to a lower punishment if that co-defendant would testify against the other?
Yes, sir.
Do you also understand that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other?
Yes, sir.
Do you also understand that the lawyer may want to use a defense theory, witness, or evidence or argument that is helpful to the lawyer's current client but harmful to the lawyer's former client?
Yes, sir.
Do you also understand that during closing argument, the lawyer may want to argue that the evidence against his current client is less than the evidence against the former client? You understand that?
Yes, sir.
If there is a sentencing, the lawyer may want to argue that his current client is less culpable than his former client.
Yes, sir.
And the lawyer may have learned something from the former client that helps the current client but hurts the former client. You understand that?
I understand.
Okay. After the explanation that Mr. Law gave you, as well as the questions that the court has asked you, and that would have been on May the 27th of 2022, plus the court's questions that I've asked today on the 18th of August 2022. Do you give this waiver knowingly, freely, intelligently, and voluntarily, and waive any potential conflicts of interest?
Yes, sir.
And that it's your desire to do so. Is that correct?
Yes, sir.
All right. Mr. Adams, anything else, sir?
No, there's nothing further.
All right. Ms. Rosenwasser?
Yes, Your Honor. I noticed that the court used the language former client. I want to be clear for the record and for Mr. Blaylock. To my understanding, Mr. Steele is actually still currently representing Mr. Blaylock on Mr. Blaylock's appeal. So it's actually two current clients. So I want to make sure that Mr. Blaylock is aware of the conflict arising from the fact that he is currently represented by the same attorney that Mr. Williams is being represented by, and that he wants to waive that conflict.
Let me ask Mr. Adams, okay? Mr. Adams, do you want to address that, sir?
Yes, sir, that is accurate in regards to the appellate matter. Mrs. Steele currently represents Mr. Blaylock, and I do not have any objection to the state asking, I guess, clarifying.
Go right ahead, madam. He's under oath.
Mr. Blaylock, do you understand that?
Yes, ma'am.
Do you understand that you are currently being represented by Mr. Steele on your appeal?
Yes, ma'am.
Now, all of those potential conflicts that the court explained to you earlier and used the phrase former client, do you understand that that applies to you as Mr. Steele's current client and Mr. Williams as Mr. Steele's current client?
Yes, ma'am.
Do you still wish waive any objection to Mr. Steele representing Mr. Williams since he is already currently representing you?
Yes, ma'am.
And do you understand that the matter he's representing you on is related to the matter that he's representing Mr. Williams on?
Yes, ma'am.
Do you still wish to waive that conflict today?
Yes.
Thank you.
Okay, Mr. Law is, I should say Mr. Adams. Who is representing Mr. Blaylock at this point in time? Does he,
I believe he's probably represented by him. I believe Mr. Lael represented him for a limited funds.
Mr. Law, is that correct? Or Mr. Lael? I'm sorry if I mispronounced your name, sir.
It's Lael, Judge. It's Lael. Thank you.
Okay. Sir, or were you engaged or hired to represent Mr. Blaylock solely for the purposes of the waiver?
That is correct.
Okay, so you do not represent him on the current matter, is that be fair to say?
That is correct.
Okay, all right. Mr. Blaylock, what I'm gonna do is, I'm gonna set your case over for the 8th of September. We'll see if we can still get you, an attorney. I can't formally arraign you at this point in time. I'll have to wait until that time, till counsel's appointed, okay? Or if you hire an attorney. So if you hire an attorney between now and September the 8th, you can let us know that. But if not, what I'll do is we'll see if we can get somebody to represent you, okay?
Yes, sir.
All right. Any other issues, Mr. Adams or or I should say, or Mr. Rosenwasser, anything?
Nothing on behalf of Mr. Williams.
Okay, Mr. Law, anything on from your perspective, sir?
No, sir, that's all I have today, Judge.
All right, thank you very much for your patience with us today. I know it's been a little bit long time being on Zoom. Thank you, Mr. Law, and unless there's anything else, I'm going to release you at this point in time. Mr. Blaylock, we will put you back on for September the 8th, and hopefully we'll have an attorney by that time for you, okay?
Yes, sir.
All right, thank you, sir. Take care. All right, anything else, or any other folks we can conduct waiver issues with?
I know he had waivers with I don't know if Mr. Stillwell's on the platform today, but I know he had some conflicts, and I saw his attorney here today.
Let me see.
Mr. Stillwell Jackson I have not seen him on the platform either, so I'm not sure if he's here. Mr. Sharp, who represents him, was present.
I know Mr. Sharp was here earlier.
Oh, there he is.
Oh, it is Mr. Sharp. Okay, all right, wonderful.
I don't know where Mr. Stillwell is.
I don't believe Mr. Stillwell is on the platform.
Where is it?
On Rice Street.
I don't think he's on the panel with us.
I don't think he was on the, let me see if he is. Mr. Chamberlain, do we have Mr. Stillwell anywhere on any one of our,
I'm sorry, I was just thinking about who we had conflicts for, that's why I thought of him.
we can put Mr. Stillwell on for the 8th. Will that work for you, sir?
It will, Your Honor. I do have a matter of business when it's appropriate. I do need to bring to the court's attention, along with the attorney. But whenever that's appropriate.
Your Honor,
but as far as
we can handle this in about 10 seconds, so if I may.
Okay.
Your Honor, and I've told counsel this because of things that will get communicated that are then put into the social media public. I have informed most of the counsel that I'm communicating in open court because I can't have everything that's happening here without social media. So Mr. Short asked me a question and I basically responded, I'm only going to respond in open court and nowhere else. I will answer his question without revealing a concern we both have. And I will tell Mr. Short at this time, we are clear. There's no conflict. Okay. And I'll just leave it at that, Judge. I think the issue is resolved and I've communicated in open court.
Okay. I know that the state filed a motion on that, a motion. Would you be so kind, Mr. Geary, within the next 4 or 5 days to file an order to that effect?
We will, sir.
Okay, all right.
And multiple copies too. We're learning.
Yeah, okay, all right. All right, Mr. Sharp, does that conclude, or your issue?
I think so.
Okay.
As long as the state's okay with it, I am great with it as well.
All right, so they're gonna do an order, basically withdrawing or otherwise satisfying they have no conflict in terms of your representation of Mr. Still.
No, this is not on the one it's filed for, Judge. This is a separate question that you wanted to bring up to the court that I would not answer. So this does not pertain to the motion that's filed.
Okay, well, I can't deal with that one until we, in fact, get Mr. Stillwell. I don't think he's on the platform today. So we will have to put him on for the 8th. Okay? For a rearrangement and for the waiver issue.
To be clear, Your Honor, so we have a conflict alleged against Mr. Sharp that I think we can relieve through waivers, but we also, Mr. Stillwell has a conflict with Mr. Steele. So as part of Mr. Steele's conflict proceedings, he will also need a waiver from Mr. Steele.
Okay. That's fine. Mr. Adams, anything on that? Is that correct? Okay, what I'll do is, let me put that on for the 8th. We'll get Mr. Stillwell produced at that point in time, and I can deal with the rearrangement and the 2 waiver issues at that point. Edward, you got those down? Mr. Chamber? Yeah, we'll need to put him down for a waiver and for arraignment, okay? Okay, all right. All right, anybody else?
On behalf of Mr. Williams, I think that's those you all want to bring today, Mr. Kendrick and Mr. Stillwell, are the ones that are outstanding that I understand will handle.
Yes, sir. Yes, sir. Okay, are there any other waiver issues that I've not dealt with today, folks? That we were able to deal with, because some people were not, either produced on or not, we're gonna get from the state system. We'll deal with on the 8th hopefully we'll deal with on the 8th of September. I also have, okay, hold on. He's not been arrested as of yet, Edward. You talking about Devorius Bradford?
I don't have any information.
Mr. Bradford hasn't been arrested yet. Okay, did we ever locate Mr. Myrick? Yeah, I asked, Lieutenant Dooley was on with us the better part of the day. I believe she had to step away to deal with some other unrelated business. And
I'm back, sir. How can I help?
did we find Mr. Myrick?
He's on 7 South.
He was on 7 South 113.
Nope, 7 South 602. Let me call again.
Mr. Theory, thank you for your patience.
Welcome, Your Honor.
While we're waiting on that, Mr. Chamberlain, any other holes or inquiry you want to make, sir? Yeah. All right. Mr. Geary?
Judge, on number 17, have you, that's Mr. Nichols.
Hold on, sir.
He doesn't have an attorney to our office, and he's in Rice Street, so we might want to bring him over on the 8th as well to try to do.
Mr. Nichols, are you on the platform, sir? I don't believe Mr. Nichols, we have him present on the platform. So I will have to bring Mr. Nichols. I don't think he has an attorney either, does he?
No, sir.
All right, we'll put him back on for the 23rd, for the
9/8.
yes, sir, the September 8th calendar.
Yes, sir.
Okay.
Hey, Judge,
Madam, yes.
do you have a number I can call you really quickly?
Don't say that number. They gonna call you, champ. They gonna violate your shit.
404-613-8741.
Oh man. Y'all got that? Y'all got that, champ? They finna violate your shit. Y'all niggas wildin'. They about to get you, champ. You might have messed up, champ, respectfully. You might have not been the move. I ain't gonna hold you. Oh, y'all wildin'. How many niggas is watching this stream? Y'all niggas is crazy. And they got the replay? Oh yeah, it's up. Come on, champ. Why in the world? See, they about to boom you. Allegedly, they about to boom on you, champ. Yeah, champ, this was not the move. Oh man, y'all niggas about to call fire out.
Go back on the record. The jail called me. They just said that they'll bring Mr. Myrick out in just a minute, okay? All right. Is there anything else we can deal with in the pendency? Any other issue? Any other?
I think we only have Mr. Myrick and Mr. Garland left, and you've got him down at 3 o'clock.
Yes, man, that's about 15 minutes from now. Yes, okay, all right.
Niggas got all that on camera. The nigga dead. Nigga better change his number as soon as it's
we can, and I will. Mr. Adams, at this point in time, do you have any? Hold on, wait 1 second. Oh, yeah.
A lot of niggas is going to jail today, respectfully.
Mr. Adams, any updates on your issue as to bond or to have that? Do you still want me to have that today?
Yes, sir. I've had a chance to consult.
I'm not calling that nigga tonight, by the way. Y'all niggas is bugging. We're not doing that. We're not doing that.
Okay, all right. Just give me a minute. I'm just gonna recess in place, Mr. Geary and et al. If you don't want to take a break, that's fine. Just come back in about 5 minutes.
They about to boom his line.
We're in recess.
You got recess copy. They about to boom his line. What is you talking about? His line about to catch the nasty boom. You better change that number immediately. Calling that nigga right now. Fuck is you talking? Yo, they calling him right now, bro.
Say again.
Oh man.
Hello.
This shit crazy, fam. Feel free to donate to the channel once again. By the way, feel free to donate to the channel for content.
Yep.
Oh man. Feel free to donate to the channel for the content. Okay? Feel free. You dig. Feel free to donate. We do have the donations right here. All the donations right here. If you want to donate to the channels right here, you dig? This is a network. This is a network. This is a network, though, respectfully. You know what I'm saying? This is a network. Cash App is right there. Cash App is right up there, champs. You see it? It's right up there. Anyone asking? Oh, you up? I see Frank lovers in the chat. You gotta take time. See, all you broke niggas. Why do you broke niggas comment? Why do you broke niggas comment? Like, who are y'all? Why do broke niggas come up here trying to comment? Oh man. That's nasty word. You know the haters get mad when you say, oh, if you feel free to donate, you know, and you post your shit up, niggas get upset. But that is the Cash App up there. That's the first thing you see right up there, man. How you gonna say I would donate? I'm gonna take. Hold on. I got you, gang. Respectfully, I don't have to read your comment, bro. You're not answering my nigga. I can't see it. First of all, I can't see your comment. Secondly, I'm not obligated to answer your comment. Thirdly, I'm not looking at your comment, nigga. Salute to whoever donates. We do appreciate any donations that goes to the channel, but y'all broke niggas is weird, bro. You know how many comments I have coming in on my channel? How I'm supposed to just specifically see your comment? Who do you think you are, or who do you think you were, champ? Respectfully. Come on, bro. We almost had 2,000 people in the chat, and you expect me to just see your comment, nigga? How does that even make sense? But okay, so if you do need an update on what happened, Gunna was denied bond. Gunna had a bond, and his lawyer requested a bond, and that request, it didn't go through. The judge said Gunna was denied bond. He feels like Gunna would cause tampering to witnesses, so he said Gunna cannot be bonded out today. Okay, that happened. As for your boy Jeffrey, aka Thugger, they didn't really say anything yet on Thug. I don't even think he has a. Did he have a bond? It's a motion hearing, so they doing a motion hearing, and I heard it was one additional charge. There was one additional charge added to Thug, I believe they said.
It's Lieutenant Dewey. Just have a seat, hold tight for me. The judge should be back in a few minutes, please. Thank you.
So the judge was saying how Thug might have had an additional charge added. That's what I did hear. But yeah, man. Podcast coming soon. Whenever we decide to do that. Right now, we just doing vlogs. That's how we doing it. But yeah, man. You dig? But like I said, man. Yeah, so Gunna deny bond. And yeah, man. I heard Thug got another charge, they saying. You know what I mean? So we learning new things. And yes, Gunna's bond was denied once again.
Yeah.
Gunna's bond was denied once again, y'all. But yeah, man, like I said, yeah, man, broke people in the chat. I don't even know why y'all come in, man. I don't know why broke people come in the chat talking foolishness. Y'all never had bread to begin with, so I don't even know why you're even mentioning anything. When this is a channel, this is a platform, and all platforms require donations, no matter what platform it is on YouTube. You know, you broke niggas who don't have anything. Y'all have nothing. Y'all bring nothing tangible to nothing. Y'all be mad when niggas talk about donations like somebody's begging for donations. Somebody's begging for anything. A lot of people have donated to the channel. You dig? Hold on. I got you, champ. You probably came from another profile too. Take time, respectfully. But yeah. Why y'all be so upset? People be providing content and broke people get mad. And by the way, first and foremost, this is a motion hearing, by the way. So because this is a motion hearing, nobody's telling on anyone. In a motion hearing, they're actually admitting to things that they have done themselves. This is not a snitch hearing. There's no such thing as that. If somebody is snitching, and guess what? If someone's snitching, they're gonna do it. They're not gonna tell you that they snitched until they testify. If they testify, isn't nobody testifying? You know what I'm saying? First of all, nobody's getting to me. Number one, hate is real. If niggas is not hating, you're not doing nothing right. Respectfully, you know. But broke niggas beware, champs. You're gonna have to take time. You're not obligated to donate to nothing. But if you're gonna comment on something because you mad that somebody's saying you're free to donate, then that just shows that you're broke and weird, and you're probably a hater. More than likely, you're hating. 10 times out of 10, you hating. That's it. You dig? You feel me? Hold on, I got you. You said, hold on, let me get you out of here. Salute to the homie Lameek Wilson with the donation. Dead Riots. I think you have too much Frank in your diet, champ. I think you have a bit too much Frank in your diet. I'm sorry, champ. You need to eat something other than Frank. There's a lot of other, meals you can eat outside of Frank, champ, respectfully. Salute to the homie with the donation, Lameek Wilson. Salute, champ. Nigga, every channel gets donations. Every channel gets donations, bro. Y'all niggas is weird. This nigga had a bag of Frank bites just now. Hey, if I get you fired on your job, nigga, well, sorry, champ. You're gonna have to sell crack. No big deal, champ. You're just gonna have to hit the streets, champ, and make sure you don't get caught, by the way. Niggas is crazy. Nasty Frank bites, nigga. Frank bites with no salt. The nigga had organic Frank bites. No added preservatives. No animal preservatives, nigga. Zero salt. Nigga, you eating a very organic, healthy Frank bites. You know what I'm saying? You're thirsty. Why you asking for donation? Hey, shut your broke ass up, nigga. Nobody asked you to talk. Nigga got on one sock. Nigga only got one sock on. He waiting for his grandmother to throw her socks in the hamper so he could take one of her socks because he ain't got no more socks. Nigga, you broke. Get a job. Indeed.com, champ. You don't have a platform where you can even ask people for donations. Nigga, you wish you had one. You waiting for your grandmother to put her socks in a hamper so you can use her other sock because you don't have an extra sock, champ. It's very unfortunate for you that you only have one sock, nigga. Get right. Get right, champ. Get right. Indeed.com. You broke bastards. Get right. Nigga waiting for an extra sock. Nigga, you should be ashamed of yourself. That ain't even your Wi-Fi that you using. It's looking real nasty. Is there another one? I see you, nigga. Eat Frank. Respectfully. Get out of here. Yeah. Yeah. Y'all niggas is moving very wacky in here. Niggas be mad, bro. I mean, can you call them fans? They be doing this all over YouTube on other people's pages. I'm not the only page. You know what I'm saying? How you gonna ask that if we needed donation on that? You should be the one that's donating. We need a donation on that. Not see y'all be waiting for other people to donate. That's not work. I ain't gonna hold you. Them low fault French nights. Food champ. She gonna have to take time. We need a donation on deck. Why you ain't send one? You waiting for another nigga to donate? What y'all looking like? What you got going on, man? Why should we? It's officially take time season. Take time season has approached us. It's time to take time, champ. It's time to take time, champ. Yeah, I see niggas lying. Stop lying, bro. Oh man. Yeah, that's nasty work. Permo flex season is amongst us. Straight permos. We giving out that perm. We giving out that perm like Soul Glow, nigga. You dig? Perm coming like James Brown back in the day. Big perm, nigga. Big permo, you heard? We giving out slick back season. It's permos, nigga. Big perm. Salute to the my shit muted for a second. Salute to the donations. We still got more donations coming in. We see y'all, man. They I got a little. They took me down for a little bit, but yeah, we still got the donations coming in. Salute to the donations and all that over here, man. Frank lovers and broke people all around the world beware. We got the flex shirts. He said the Million Man perm off. Gotta get them flex shirts out. Permo flex. Changing the game. Salute to all the donations and all that. We appreciate you. Oh man. Trial is in January. Trial is actually in January. But they took 10 minutes, 20 minutes, and you already know that they already told him the judge was filing. He gave out his phone number. Phone and booming his ridiculous. They are booming his nasty work. But look, y'all, make sure y'all smash the like button. Continue to smash the like button. Let's get the likes up. Showface News is officially over 20,000 subscribers. Salute to all the support. Salute to the day one. Salute to the real supporters. I appreciate you on the channel. Definitely, put in work. Salute to y'all, man. Full marketing. Donations. Like I said, officially over 20 subscribers. 20K plus subscribers. Really gonna be big. Y'all, man. Feel me? Salute to y'all, man. We definitely got a lot going on today. Waiting for this to end too, by the way. We just waiting for this to end. It's gonna be a good day, bro. It's gonna be a very good day today. Yeah, man. But anywho, as we wait for them to come back, if you are a supporter of the channel, we do have a Patreon, and that is patreon.com/toughhouse1. Patreon.com/toughhouse1 is where we have very exclusive content that cannot be on the Showface News channel because it's very raw and uncut, and it goes against YouTube guidelines. So if you want to get a very, very good laugh every day, we have over hundreds of hours of comedic content here on this Patreon, and that is patreon.com/toughhouse1. We have the Toughathon shows up there, the Tough Houses up there, a lot of roasting sessions. We got prank calls. We got all types of things over here. We also will be live again tonight. You dig? So make sure you tap in tonight because we will be doing prank calls, roasting, and music reviews. So tune in tonight, y'all, especially for the new subscribers. You will enjoy our tonight show that we have every night, man. Make sure you tap in. Be here. Well, become a patron. Become a patron today. That's what we got. Really exclusive content. Salute to y'all, like I said. Make sure y'all get the likes up, though. Make sure you get the likes up. You dig?
Okay, so did you get my text?
I gotta listen to it. Yeah, man. We waiting for them to come back. I'm sure the judge is getting his homeroom. Oh, Fox effect. You gotta go, champ. You gotta get that promo. Not only are you out here simping, you weird. I don't know if you referred to me as a Satanist. I don't know if you referring to me as a Satanist or whatever. Maybe I am, champ. Now, what are you going to do about it, champ? What will you do if I am a Satanist, champ? Nasty work. I said, make sure y'all get your mics up respectfully. But Gunna has been denied bond. Gunna was denied bond. Thug is supposed to have gotten I believe, what did he get? Thug got charge added. He added one more charge for Thug. So yeah, man.
I talked to his mom. So he was out straight edge with basketball.
Hold on, man.
Just got torn.
Let me see something.
It definitely seems like I read the police report. Out there. Kind of made comments. Not like that.
What's going on? How's the audio now, though? It should be good now. Audio being weird. What happened, y'all? We good? Say yay or nay. What we doing? How's the audio now, y'all? Oh, Frank Love. Oh, here go to Frank Love again. I got you, gang. Don't worry. He gonna get you right, man.
I started off with
like I said.
I ended up in that game case.
Like I said, they supposed to have added a new charge to Thug. Thug was supposed to have a new charge and all that. So that's what happened. As far as Gunna, he was just denied bond.
Please be seated, everyone.
You know. It's crazy.
Okay, let's see if we can find Mr. Myrick. Mr. Myrick?
Nigga, those
Thank you,
timeouts,
sir.
those timeouts is for niggas who's on they BS, my nigga. That's why they getting timed out.
It's number 14 on the clean arraignment calendar.
Cold-blooded, salute, champ. I see you.
All right, good afternoon, Mr. Myrick, and good afternoon, Mr. Theory, and good afternoon, Mr. Geary. This is Mr. Theory. Your client was originally brought over an indictment 22 SC 182273, and that matter has been re-indicted in 22 SC 183572. Are you aware of that?
Yes, Your Honor.
Okay, all right. Do you wish to go ahead and waive formal arraignment in the new indictment? Otherwise, have the court enter a not guilty plea on behalf of your client and have at least 30 days upon the receipt of discovery to file any motions?
Yes, Your Honor. We would ask to waive formal reading and to get the 30 days to file motions.
All right, I'll put it on for January the 9th of 2023. Sir, have you filed a motion for bond or anything such as any other motions pending?
Not at this time, Your Honor.
Okay, all right. If you should file any motions, please let Mr. Chamberlain know, and I'll go ahead and we'll see if we can get you scheduled accordingly. Okay.
Yes, I will send courtesy motions to Mr. Chamberlain.
Okay. Yeah. Sir, let me just ask you something. Are you going to be asking for bond in this particular case?
It's likely that I will. I will be going to visit Mr. Myrick, and we'll go from there. Yeah.
Okay, all right. I'll wait then, all right? Okay, just want to make sure.
Yes, sir.
Okay, do you have anything else, Mr. Theory or Mr. Geary?
No, Your Honor.
Okay, Mr. Myrick, I'll release you at this point in time. Mr. Theory will come to the jail and talk with you, okay? All right, thank you, sir. Who's got the phone? Huh? The phone. Oh, okay. All right. Is Mr. Garlington with us at this point in time?
He's the one marked River Bend.
Thank you, sir. All right, Mr. Lewis, I'm move you over here. CNN.
Good afternoon, Judge. I'm here.
Hey, good afternoon, sir.
Good afternoon, Judge.
It's been a minute since I've seen you, but
Yes, sir.
good to see you. All right.
Oh, I say I gotta boom somebody. One of y'all niggas was pump faking, and I'm gonna have to violate you. Take time, champ. You get the permo. Y'all niggas be playing.
All right, Mr. Lewis, thank you for your patience. I know you've been on a little bit. Mr. Garlington, given the schedule, was only available as of 2 o'clock since the morning schedule was kind of full. But at this point, he was on for arraignment in indictment 22 SC 182273. That matter has been re-indicted under 22 SC 183572. Sir, are you aware of that, Mr. Lewis?
Yes, sir, I am.
All right. Sir, do you wish to go ahead and waive formal arraignment on the new indictment, otherwise have the court enter a not guilty plea on your client's behalf and otherwise have at least 30 days to file motions upon the receipt of discovery?
Yes, sir, that is our request.
Okay, all right. I will go ahead and grant that. Sir, have you filed a bond motion as of yet?
Judge, a bond motion was filed on the prior indictment. Mr. Garlington is serving out a very for technical violations. So it is moot at this point, but at some point I will refile under the new indictment for a bond motion. Yes, sir.
Okay, when you do so, let us know, and if you would send all those concerned from the state as well as Mr. Chamberlain and Mr. Kearns, the court staff attorney, any motions that you file or any request for bond, we can go ahead and schedule those. I will go ahead and place you on the 9 January 2023 trial calendar. As I mentioned, any other motions that you file in the pendency, please make sure that you copy the court and Mr. Kearns, as the court's not an e-file party, okay?
Will do, Judge.
Okay, Mr. Garlington, Mr. Lewis will be back in touch with you, get you ready for trial, and he'll be talking with you soon, okay?
Yes, sir.
All right, thank you for your patience, and you can be released at this point in time. Mr. Lewis, you have any other business before me?
No, sir.
All right, I'll release you at this as well this time, sir, okay?
Thank you, Judge.
All right, thank you. All right, counsels, were there any other than the bond, are there any other folks I need to take up, or any other people that I've missed? Any other waivers, Mr. Adams, or any other ones that I have missed at this point in time that otherwise are not in custody or? Okay, all right. Okay, all right. Okay, at this point in time, we're going to take up the matter now in under the new indictment. That would be 22 SC 183572. I'll note for purposes of the record, Mr. Steele and Mr. Adams, that you did file that motion under 22 SC 182273. I will just continue it and
including representations made by the state for denying bond for Mr. Williams. We have filed subsequent to that a motion. The motion is before the court today for reconsideration of denial of bond, and we have put in that motion and are here to argue today that there were consistent, numerous, and material misrepresentations made by the state.
My fault, y'all.
This is not an attempt to cast aspersions upon the motion.
The shit crashed.
To factually correct some things on the record.
Yeah, the shit crashed, y'all. That's my bad.
Denial of bond was based on
I don't know what type of weird shit they got
several of
going
those
on.
representations taken that the court took.
But you're watching Young Thug's defense right now, so y'all know.
If the court were to consider the information put before it without those misrepresentations, then it would appropriately reconsider its decision to deny bond for Mr. Williams. As you recall, Your Honor, we placed before the court several options that we believe would have satisfied the court under all of the Iowa factors, and did in fact make out mechanisms by which the court can be assured of Mr. Williams' return to court whenever ordered, without going into any tremendous amount of detail. It was a day-long hearing. But, you know, to put it in, synopsize it, that's the proper word. We, of course, suggested to the court that at Mr. Williams' own expense, we would arrange for 24-hour law enforcement monitoring of his residence. We offered to the court that his residence could be swept prior to his arrival to make sure that there are no mechanisms by which he could communicate that would not be available, would not be known to either the state and or the court. We suggested that Mr. Williams would be amenable to 24-hour house arrest if he would not leave the home absent court appearance or authorization by the court.
And I did hear testimony from Mr. Charles Middlestat to that extent, and a document was introduced synopsizing, that your word, his or reducing his plan to writing for the court.
Yes, sir. And obviously, I know that the court was attentive and took notes and paid attention to all of the things we proffered, all of which we believe should have or would satisfy any court, quite frankly, in being comfortable in releasing the defendant on bond so that he would reappear for the appropriate process down the road. As we move forward, however, it's incumbent upon me, I believe, to ask the court to take note of what we've placed in our motion. And I'm sure that the court, as it always does, has had an opportunity to read the motion that was filed on June the 28th of this year, as well as I believe we filed it previously, and we filed an amendment adding some additional.
Yes, sir.
If the court has an opportunity, I'd like to go through some of the things and put on the record what we believe were decided misrepresentations by the prosecution and make some corrections for the court's consideration.
All right, go right ahead, sir.
Thank you, Your Honor. One of the things, and looking at number one, under the material misrepresentations made by the prosecution, that I think the court paid particular attention to was that the prosecutor asserted that the state was in possession of a recorded telephone call from the county jail in which Mr. Williams admitted that he was addicted to drugs and needed to detox. That was a material misrepresentation. This recorded phone call was not played. It was referenced by the state, but we have obtained that, and we sought to get the actual recording from the state, and we ultimately obtained it ourselves. We had an opportunity to go through that recorded phone call and listen to it, and listen to everything that was said. Mr. Williams did not make those statements as represented by the state. He did not indicate that he was addicted to drugs and needed to detox. In fact, what he indicated was that he was going through withdrawal from being separated from his significant other. A material difference. And that's particularly important because the court may recall that one of the things that we presented at the bond hearing was the fact that Mr. Williams had been getting drug tested for well over a year, maybe 2 years, as a condition of bond in another matter, that he was not addicted to any substance, he was not using any sort of drugs, and then had the state's representation been true, would have flown in the face of that fact that we put forth affirmatively. And so we believe that material misrepresentation was inappropriate, and the court should reconsider based upon that fact that he did not make that admission that would have been of concern to the court. Your Honor, we also indicated that the prosecutor declared, and this is really more in the way of argument, we believe, because there was no factual information put forward. The prosecutor declared Mr. Williams had access to helicopters, private jets, and because of that is a flight risk. That simply is not reality. Mr. Williams does not own any jets, does not own any helicopters, and does not have any greater access. There's been no evidence to indicate he has any greater access to private jets or helicopters or any other means of transportation that anyone else does not have access to. And given that our recommendation was that he be confined to his home at all times, with the only exception being for him to come under the auspices of law enforcement to come to court, we believe that representation by the state was not one and is not one that the court should or could seriously consider.
I believe Mr. Geary did mention that one of his residences is near PDK, Peachtree Cab Airport, and that it wouldn't be much for him to cut his ankle monitor if I gave one, and or money to be to be given for him to be able to make that type of that. I think that was Mr. Geary's argument last time, but I understand what you're saying.
Yes, I do believe that was the argument, and my response simply is that Mr. Williams would not have any greater ability or access to do that than any other individual. And there's no evidence that he would in fact do that. Supposition is not sufficient for a reason to deny bond. The prosecutor cited in Overt Act number 4 that Mr. Williams, back in September 9th of 2013, was in possession of a stolen firearm. So I wouldn't consider that to be put that in a different category. I understand their assertion based on the fact that he was charged with that offense, but constitutional guarantees mean more than just words. And in that particular case, I think the state is aware that if the court is not, I can tell you as an officer of the court, that there is no showing that Mr. Williams was knowingly in possession of a stolen firearm in 2013, almost a decade ago. That case is a case where he was charged, and the case was dismissed after successful completion of the pretrial intervention program. Now, entry into and completion of a pretrial intervention program is not an admission of guilt. It is a matter of resolving the case. And I don't mean to preach to the court. The court knows this. It's a matter of resolving the case based on practical considerations. There was never the issue of whether he truly was in possession of a stolen firearm, vetted or put before any court or any jury for that determination to have been made. And so because he always enjoys the presumption of innocence, even after he has entered into and completed a pretrial liberation program, I would submit to the court that that assertion by the state is not something that could or should have been considered as a reason for denial of bond. Overt Act number 9, excuse me, and this, I won't go through all of them because this actually addresses some of the other arguments made by the prosecutor, specifically in reference to song lyrics. I know we talked about this a good bit in the last bond hearing, Your Honor, but I really wanted to harken back to that. Overt Act number 9, as referenced by the state, concerned allegations that on April 20th of 2014, there was a song titled You, E-W-W, and that it contains lyrics along the lines of all I ever wanted was the money, and that people wind up in wheelchairs. And the prosecution put that before the court as a way of arguing that Mr. Williams is a danger to the community, as evidenced by lyrics in the song. This and other overt acts that reference song lyrics by Mr. Williams or song lyrics, I think is inappropriate for the court to consider as a reason to deny bond for a number of reasons. Number one, there has been and was not any showing by the state that the lyrics that it referenced, either in that overt act or any other overt act, were lyrics that were either written by Mr. Williams, thereby indicating some sort of mindset on his part, or authored by him, sung by him, distributed by him. I think it is tremendously disingenuous and quite frankly very dangerous to take song lyrics where there is no presentation or no representation made about the origin of those song lyrics and use that against Mr. Williams. There are, in this and in several other overt acts, there are, I'm not necessarily suggesting, although it would be a bad idea, that the court, number one, go and listen to the actual songs that were quoted, or that the court do any independent research with record labels to determine who actually wrote those songs or who actually, which artists, where there's several artists in the song, which artists actually sing the lyrics that the state is referencing. But I can tell you that we've done that. And as an officer of the court, we know, I'm telling you that we know that there are several lyrics that are referenced that simply are not Mr. Williams. They're other artists. There are several songs that were not written by Mr. Williams. And so it is not just misleading, but it's dangerous to.
So which ones were not written by him?
And there is a song, Anybody, and I don't remember which. I'm going to need to refer to my indictment, where the state quoted lyrics along the lines of, I've never killed anybody, but I had something to do with that body. That is a song that was written by 3 individuals, by Mr. Williams, by Nicki Minaj, I forget her actual name, and a third author. And there are lyrics quoted that were not written in that particular song by Mr. Williams. That is one. There is In Overt Act number 60, the state referenced a video released on social media titled, quote, "Slime Shit." And the lyrics that are quoted in that is not a song that was written by Mr. Williams. It was a different artist who wrote that song, and none of the lyrics in there can be attributed to Mr. Williams. And my point is,
who wrote it?
This nigga lying.
An artist by the name of Roscoe.
Okay.
I can get to the full name if the court desires.
That nigga Thug don't even read right. Freestyle artist.
I know it's not Mr. Williams.
But Anybody was written by Mr. Williams and Nicki Minaj and one other person, right?
That's correct.
Okay, all right.
And there's some others that I need to go through and search for. What I'm suggesting to the court is that I keep using the word dangerous.
Thug don't even use. Thug don't.
The state doesn't say that. The state in their presentation says to you that Mr. Williams did this. Mr. Williams said that. Mr. Williams wrote this. I don't think they said he wrote it. They said he formed what it said. And that's simply not accurate. And so for the court to, asking the court to consider that is dangerous and is inappropriate. It doesn't give the full story, and the court needs the full story and accurate facts in order to make a determination.
Y'all know Slime shit got Gotti on it too, right? That's Plug in Yak Gotti.
That the state put forth, that the court actually took particular interest in, and I'm looking now, paragraph 6, where they reference in Overt Act number 25, they allege that on January 25th, 2015, there was an audio recording of Mr. Williams declaring that, quote, "Sacrifices must be made, soldiers must fall in order for the battle to be won." And the state argued that that was a, quote, "call to battle for criminal street gangs." Now, I will say Mr. Gary, when pressed, was not sure whether this was an audio recording in digital format or possibly a group chat. This was not a statement made by Mr. Williams. And as a matter of fact, I think the court asked Mr. Gary about that on 3 separate occasions, about the format of this statement, where the statement comes from. And so I believe the court was misled in that regard, in them saying that Mr. Williams made those declarations when he simply did not. It's not accurate. That's information that the court used to make this decision that is simply not accurate information. The prosecutor made a claim that on January 26, 2015, approximately 16 days after the killing of an individual was named in the indictment, that Mr. Williams released a video stating, quote, "If anybody goes into a courtroom and tells the God honest truth, they need to get effing killed," and that this threat is still being discussed by witnesses today. That was an absolute misstatement of the information that we've been provided. It's taken out of context. There are sentences that are put together in the representation made to the court that aren't in fact together, and it is put forth as a representation for something that it is not. And again, the state has the ability to give the court the entire, whether it's a social media posting or a recording or anything else, so the court can see it. But making representations that are not accurate, again, runs the danger of the court being led or being misled about the true contents of any statement allegedly made either by or with the presence of Mr. Williams. and we started discussing a little bit earlier, was the prosecutor saying that Mr. Williams has lyrics in his songs containing references to, quote, killing police officers and judges, particularly, and, quote, mob life. And I don't think that that was inadvertent or unintended. I think obviously saying that this defendant who was before the court for a bond has authored or uttered lyrics about doing damages or killing judges is something that's extremely prejudicial, but it's inaccurate. That is in our paragraph number 9, that is the recorded, that is a statement that was authored by Roscoe as opposed to by Mr. Williams, and it's simply not accurate and not true and not appropriate to say that Mr. Williams is the author of that statement or the person who uttered that statement and have the court consider that as a reason to deny harm. My argument, I guess, Judge, in regards, and I don't want to limit it on time, but I do want to take my time, but I also don't want to just belabor the point. What I'm getting at in regards to the lyrics is that if you're going to say that those are things that the court should consider, they've got to be accurate. And they can't be misrepresented, they can't be taken out of context, and then they can't pick and choose, pick one sentence from a song, another sentence from part of the same song or another song, and put it together to try and intimate that the defendant has a particular mindset that the court ought to consider in regards to denying the granting or denying bond.
I ain't gonna hold y'all. He threw Nikki name under the bus. And he threw somebody named Roscoe under the bus. And I ain't gonna hold you, man. That's nasty. You throwing names in there. You know what I'm saying? The people he supposed to be cool with in the name of granting bond is crazy. I ain't gonna hold you.
Things that the state argued are matters that I think anyone would consider trial issues. And I heard the court say a little bit earlier that those are issues for trial. Whether or not the person is not guilty, is innocent, or whether someone actually did something that is alleged in the indictment. Those are my matters for trial, not matters for consideration of a bond. And there are several arguments that were made, several things. And of course, again, the court has the motion, and the courts have an opportunity to see what we've said in the motion. But they are, the majority of the rest of it are things I would say to the court that we disagree with. We think that given an opportunity to vet them before a jury or even before a court, that we'd be able to disprove some of those things, but those are matters that should be disproved at trial, not at a bond hearing. I'll sit at this point because I've said everything I believe I need to say in regards to our motion for reconsideration. I'd ask the court to give a careful look at the representations that were made, what we have rebutted in those representations, what we have clarified in regards to those representations, and to reconsider the decision that the court made back in June, and also to take into consideration everything that we had an opportunity to put before the court as alternatives for assurances that Mr. Williams will return to court.
All right, thank you, sir. All right, Mr. Geary, or Mr. Smith, or Mr. Rosenwasser, go ahead.
Judge, what counsel harps on about he didn't write this, he didn't write that, where this seems to go is what he just said they didn't want to do. He's basically saying, we disagree with the evidence that's going to be presented in trial. And that, again, as he did correctly state, is something for today. The phone call that he got that he wants to classify not someone to his significant other is kind of troubling because the person living in line was the defendant's sister. So if he is claiming that's his significant other, that's just a whole other issue. They can claim that they interpret the call different. The call is what the call is. He claims he's got what he needs for his detox there at the jail. And that's straightforward, and it is what it is, Judge. If they want to say it's something else, again, that might be a matter for a jury to determine what's on the call and what's not. But that's what the call says. That he didn't author the actual songs. Well, as we get to the trial evidence, that's not the law. The law is if you sing the song, it's an adoptive admission. You don't have to write them. But that beside it, when he starts saying, when you start looking at slang shit in anybody, I invite the court. Look up on iTunes. It says, written by Jeffrey Lamar Williams.
Exactly.
Right? That's everything we see is there. If he wants to come in and say, I didn't write that, that's fine. It's in contradiction of what's out there and what is posted as being the truth. Those songs indicate that he wrote them. Now, that aside, it doesn't matter. If he sings them under all law, it's an adoptive admission. So, and the one who said Roscoe, he didn't give you the name on it, respectfully, I did. That's a Jimmy Winfrey, a member of YSL who's involved in these crimes. Every one of them here want to be a rapper. Right now, there's Mr. Kitchens, there's clearly Mr. Williams, and they're very successful at that. Other members of their gang are writing about the exploits of the gang, and Mr. Williams is singing about some of them. In fact, Mr. Williams didn't actually write that I didn't kill anybody, but I got something in that body, is still biographical. He's still in that role. That's still the truth, and we still intend to prove that, Judge. And again, it's an adopted admission. It doesn't take away anything that maybe he's not the one that penned the words. But again, as listed on iTunes and other such places, it says he wrote the songs. And maybe he's just doing that to get the credit, but he's going to come in and say, oh, that's really not true. Again, it's immaterial. Judge, what this is, and they're saying, okay, he was discharged because he went to pretrial intervention. I don't care. He's still in possession of the stolen gun, and it's still a trial fact for the judge to be able, for the court, the state to be able to prove that he's aware that he knew it was a stolen gun. And the reality of it is, they have so many stolen guns that we have the ability to show that always possessing these stolen guns, they knew or should have known that they were stolen when they get them, and how they procure them. That's a trial presentation, and we're going to be ready for that when it comes, Judge. What they're basically saying is we disagree with the evidence, so because of that, we say it's a material representation. It's not, Judge. Okay, at least I'll stand in my place as the prosecutor and say, is what we believe the evidence is going to show you. Now, I'm not clairvoyant. Mr. Adams still may get to trial, and they may be right. They may prove that I'm wrong. I may prove that I intend to that they're wrong. But that's a trial issue. What the statement said in the call, it says. What this evidence says, respectfully, it says. If those songs are adopted admissions, he sings them. And even one case goes so far as to say, even if another member sings it, it's an adopted admission if you're in there. The same thing with if you're in a song singing about your gang and all your gang members are in there, it's an adopted admission by them as well, even though they're not singing and they didn't write. Judge, I would say that they ignored the law when they argued the points. Your Honor, they argued to the acts of 16, 17, 18, 19, which is the murder of Gunna and Thomas. They want to say that there's no credible evidence and therefore it's prosecutorial misrepresentation. I'd ask the court to wait for trial because I was really the fact that there's going to be evidence on it. I'll just put it that way, Judge. Sacrifices must be made. Your Honor, to my knowledge, those are the words of Mr. Williams. In that string, and it's a group chat. To my understanding, I'm wrong twice today, the Judge. I could be wrong again, but to my understanding and knowledge, those words are Mr. Williams. So I think what we have here is they've gone through the indictment and they want to reclassify or put defense spin on the evidence in the indictment to say that I'm materially wrong. I still stand behind the representations I made, Judge. And I believe this is going to be the third, if if I'm not mistaken, time they've asked for bond. They denied bond on 5/11/22, 6/2/22, and I don't know what the court's going to do today. But on 6/2/22, the court denied it on all four bases. And Judge, we stand behind the representations we made. To my understanding and belief right now, they were all correct. They might have a different spin on them. They might be telling or forecasting what their trial strategy is to fight the evidence. But again, that's a trial strategy. I can tell the court, I'm sitting here looking right now at one of the ones for slime shit. It says written by Jeffrey Lamar Williams and Ricky Harrell, Harrell. That's wrong. That's what he's putting out. If he wants to change it, there's nothing I can do about that. Judge will deal with it when we get there. Your Honor, he runs, and I mean he runs, he's the general. He says in the song, he's the general. He runs a very violent street gang that has committed numerous murders. Respectfully, Judge, if he's let out with the number of people that are still out there in YSL, I would expect that to continue, and I would expect witnesses to be in danger. Again, I have nothing specific that Mr. Williams has made a direct threat. This is the gang, members of the gang, relations of gang members here that are in jail on this case have made them. One of them is actually in jail for that threat. And I don't know any way to put it, I don't mean insult the court, but this is the real deal, Judge. These are very violent people, they're dangerous people, and I believe the finding on June 2nd is correct. We'll flush this out at trial, but all four of those factors still apply. There has been no material change. There has been no misrepresentation. There's a disagreement with what the evidence at trial is going to show. And I believe then that means they do not counter the order that the court signed on June 2nd. They do not carry the weight on the ILL factors, and I ask the court to deny bond again.
It's over with, gang. Respectfully, it's over with.
You may.
That prosecutor gonna eat them alive when it comes to that goddamn trial in January. I told y'all, man, he gonna go hand.
For everybody. Your Honor,
They go for
please grant bond for Mr. Wood. I believe without any hesitation that there are conditions that can be fashioned that will ensure that Mr. Williams comes back to court when required to do so, not intimidate witnesses of the danger to the community, live properly in the community, will not commit a crime while out on bond. I had the benefit of my life knowing Mr. Williams for almost a decade. I saw his rise to international prominence in his field of choice of art. I also had the honor, shot to go into the neighborhood that he was raised and other people who come from poverty. I'm sure the court has. He has been shot. He has been hungry. His family held it together as best they could. He grew up in a place that in America, in 1990s, nobody should grow up like that. And he's being ridiculed now because he talks about that life and what he's seen. He shouldn't. He's bringing people doing hip hop and rap are bringing to the attention of people who have no idea what it's like to be in the inner city growing up. He is educating all of us. He should be applauded, which he is applauded by most. The fact that we are talking about lyrics and songs is to me, and you're going to get a motion from me and Mr. Adams. So please keep it out. It's admissible evidence. Because I don't see that happening to people who write books. I don't see that happening to people who act in movies or produce movies. I don't see it happening to people who paint portraits. But it happens in music only to people who do perform hip hop or rap music, which to me is discriminating. Because I don't see it happening to people who do rock and roll or.
Here we go.
Same type of lyrics. Jeffrey Williams, Your Honor. I know you don't have the pleasure of meeting him. You've heard him today, you've heard him before. He's most polite. He's a genius. He understands that we're fighting for his life. He would not risk anything on bond. The fact that Mr. Geary, and we all agree, everyone says these are trial issues. They are trial issues, but Mr. Geary wants to use them as bond issues. Mr. Williams is presumed innocent of any crime. He has no history. And while Mr. Geary said we can disagree and he will defeat us or we'll defeat him in a trial, that's fine. But at a bond hearing, we shouldn't even be talking about the allegations in the indictment. Those allegations are what they are. They're hearsay evidence that Justice Huntsman taught us about that are just put into an indictment and affirmed by a grand jury. So the real evidence you have before you is you have a young man who sits in a Cobb County jail. I see him almost every day. And we work his case every day. And he should be in a house without any internet, without any electronic data, without any access to anyone, except his lawyers or about the medical emergency, with sworn law enforcement officers surrounding that house. And we can move him out to the country where no one's around him. We can secure his place and no one knows where he is. That is more humane. I ask you to please grant him bond. I will tell you, I will go visit him every day. If anything happens, we can put somebody from the district attorney's office, from the court system, from my office, from Mr. Adams' office, in charge of ensuring that those officers are constantly updating everything, and there's surveillance cameras that can be put. Your Honor, Mr. Geary, he knows my feelings for him. He is wrong. He says that Mr. Williams is on some sort of chat group talking about soldiers and people, sacrifices must be made. I have it in discovery now. I didn't have it when you originally heard it. My insight sat there and I didn't say anything because I didn't have the information. But I have it now. I can show it to you now. Mr. Williams is not on that chat. And I heard Mr. Geary say he may not be right, he may not be on it. I'm telling you he's not. I respectfully ask you, Brett Bond, Mr. Williams has been targeted for about 7 years by law enforcement. He is in this case by shooting a bus. Shooting at a bus as a co-defendant. Mr. Geary is the one who prosecuted Mr. Williams in Cobb County. Mr. Williams was not indicted in that case. He's indicted now. There are problems with this case for the prosecution, and the problems are not solved by January 9th trial. Every day in jail is a day. I want to thank you, and I hope I'm going to be some sort. I'm not trying to waste your time. I'm just
not wasting my time. It's your job. I mean, and with any of this, look, there is natural friction between the court, the defense, and the state of the government. That's healthy. So your statements to me, Mr. Adams' statements to me, Mr. Geary's statements, anyone, I understand it. I understand what they mean, and I understand, what my role is in this. And we're going to disagree on certain things, but you can't, no harm in asking. Court doesn't feel offended. Court has the responsibility to listen to whatever's proffered in front of it. And I take that responsibility very, very seriously. And I also understand that with any criminal accused who's pending trial, they are presumed to be innocent. So I understand that, Mr. Steele, and we may disagree sometimes or disagree, and I'll make rulings, which you certainly, as I always tell people, you can have my homework graded. That's the beautiful thing about it. and I won't feel offended at all.
I know there has to be, under the way that Mr. Williams has access to resources, there has to be a way to allow, satisfy the sovereign court that he can be granted bond, and then with all conditions. If they'll put him in a jail, but just outside the jail. And he doesn't have to have any type of communication with anyone else. We don't need that. He is in such a bad position now. Anything would be better. Be better for preparing the case as well. I know that you're not concerned for the court, concerned for you. With that being said, Your Honor, you said last time, before you're on the court for a motion to bond, and you did all four factors and you satisfied. You said the primary ones, group chat messages from 2015, the fact that the threat, that message is still being talked about. That message, Your Honor, is a statement that is reality. The court sees it, the prosecution sees it, the jury sees it. Everybody, news media sees it. All he said was, I don't get it. People lie to their mothers, lie to their fathers, lie to their brothers and sisters. And then they come into court, raise their hand, and swear to tell the God's honest truth. Those people should be killed. Talking about, if you look at the date that was made, January 26, 2015. There's a well-known case right then that an innocent man spent 30 years in prison based upon the lie of a well-known town liar. And 30 years later, it was proven innocent. The district attorney's office dismissed the case. And that should not be a reason to deny Mr. Williams a bond. And in the background, we blow up that recording. You hear people saying, I'll swear to tell the truth, and then I'll lie to God. They're talking about witnesses lying to them. That happens. That's not a reason to deny bond. Your Honor, we will stand in court in any type of condition. He will not leave that house, but he should be respectful. Mr. Williams meets those four points. Respectful. I ask you to grant a bond that he cannot leave, he's surrounded, and he will be embraced, and the only people that can visit him are people approved by the court, and the district attorney will know about it. It will be the defense team, and that will be it. And that will be hardship on his family and his friends, but so be it. You can't see anybody now. I want to thank you.
Can I respond?
Yes, you may, sir. Yeah.
A good point was made up, and targeted by police. I don't find that anywhere, Judge. And the concern is when they say he's nonviolent, it's this. I want to remind the court, one of the reasons we re-indicted is to add the charges from the arrest on May 9th. And one of those charges is possession of an automatic weapon. There are other weapons in there. Now, as we stated, Mr. Williams is not a convicted felon, he can have weapons. He can't have an automatic weapon. And there's other drugs located in the house. And I believe there was also a small child in the house there with those weapons and those drugs. Your Honor, quite frankly, the case that we see and the person Mr. Steele just spoke about, those things don't do this. They're not, that's not accurate. This is a dangerous person. And Mr. Steele's got a job to do, as the court said, and I respect both Mr. Adams and Mr. Steele for doing their job. But that's not real. The real world is where we live in here in Atlanta. And YSL is a dangerous gang, and this is the man who leads that gang, and he's dangerous. And I ask the court to reaffirm your findings from June 2nd and deny bond.
Yes, sir.
The last grace about it.
Sure. Can you do it in under a minute? Because you will wax on. If I don't cut, I'd give you a timeline. Okay.
The 14-year-old child, Mr. Williams, has custody. That's his son that was in the home on May 9, 2022. The gun that Mr. Geary is talking about, law enforcement officers surround the house. They were not in uniform. People in that house, multiple people actually, 10, 12 people in the house. My number may be a little wrong, so I apologize. There's surveillance around the house. The person exits the house, not Mr. Williams, with that gun. That's not Mr. Williams' gun. So to sit here and say it's Mr. Williams' gun is wrong. And that surveillance video, I presume the police have it because they know he's come home. In addition, Mr. Williams self-surrendered to them. He called me. He said the police are surrounding my home. He said, surrender, and I'll come over. He said, okay, that's what he did. Then finally, Your Honor, I hear Mr. Geary, he tells me this, he tells me off the record, not on the record. He always tells the same thing, Mr. Williams is part of this gang. Mr. Williams is a role model to most. He is a non-gangster, but he grew up in an area that he understands that lifestyle. But he is an artist, business person, father, and son.
I'm going to take a few minutes, Mr. Geary and Mr. Steele, Mr. Adams, Mr. Smith, and Ms. Rosenwasser. Just give me a few minutes. I'll come back out in a minute, okay? All right. We're going to be in recess.
Oh, man. Hey, look, man, it's over with, man. Look, Gunna was denied bond. In case you late, Gunna was denied bond, okay? Thug is about to get denied bond. If Gunna is getting denied bond, what makes you think Thug is not going to get denied bond? Okay? So, yeah, you pretty much understand what this is. Niggas trying to wrap it up and end this. And Gunna was denied bond, and Thug, the game show, is about to get denied bond, okay? Period. Again, niggas did exactly what niggas said they did. And there's really no need to put everybody else's name on the lyrics because song lyrics is just one small portion of what's going on here. These dudes was doing way crazier things that confirm they did what they did outside of the song lyrics. The song lyrics were just confirmation more of what they did. I'm saying, now you had a snitching little Woody who was giving them all the details of the language and all that. You understand? So for anybody who thinks that they innocent for any reason or thinks that, oh, okay, look, these dudes is being targeted, this is not facts. The fact of the matter is these niggas was terrorizing Atlanta, they was terrorizing the slums, and there was millionaires doing it. You can't mix street life with a life of luxuriousness and entertainment, period. You understand? Facts is facts. If you know, you know. Niggas been knew about the YSL shit for years. Now, a lot of this shit is new to y'all because y'all not tapped into Atlanta, so y'all don't know that these niggas been on bullshit. You know what I'm saying? Y'all think that Gunna is innocent when Gunna is not innocent. Gunna been on street shit for as long as, y'all knew him. He's been on that. Your man's Gunna was out here making plays too. So, yeah, read the indictment. Read the indictment. That's all I have to say. These niggas have definitely been responsible for being innocent people smoke too. Like, come on. What they say? Don't do crime unless you're tough. If you're not tough, stop doing crime. It's that simple. If you're not tough, don't do crime. Because you're going to be going to a place that's rough. So, if you're not tough, stop doing crime. Niggas is criminals, champ. Niggas did everything that they said they did. Niggas ain't hide nothing. They went on video and did it. They did videography with it. What more do you need? If you're going to talk about a crime that you actually did on record, what you think gonna happen? You must have wanted to get locked up. The nigga Young Thug was flexing. He flexed. He said, fuck the courts. They know about these bodies, but fuck the judge. what I'm saying? I paid $1 million. I paid $2 million to the lawyer to make the bodies go away. Nigga, it's the whole song. You flexed. So you was ready for that. You can't get mad at nobody but them niggas. You can't get mad at nobody but them niggas. You know what I'm saying? You are responsible for homies, 50 bodies plus. You know what I'm saying? 50 bodies plus. And niggas is talking about freedom. Niggas got a whole 14-year-old killed on Cleveland Avenue in Crossfire. You know what I'm saying? It's nasty work. Gunna and Thug was in court with each other on the big screen right over there. And Thug is still on the screen right now on the top corner. I mean, niggas asked for that. That's all I have to say. Niggas asked for that. That's all I'm gonna say. No. Some of these deaths were recent too. That's the crazy part. Niggas is out here just saying TikTok. First of all, they did get arrested. This is how I know. See, people speaking on something they don't know nothing about. Thug and Gunna already got arrested. Thug got arrested 38 times before this, and he found it out. They kept giving Gunna and Thug chances until they hung themselves. You niggas ain't even keeping up with this shit. And you trying to tell me about something. Understand? You know about them niggas Thug and Gunna was getting arrested anytime before this. How did this did? They found it out. The state was building a case and the whole YSL the entire time while they was getting arrested. They were just waiting for them to give themselves enough rope to hang themselves with, because that's how they play it. You just don't know that because you don't understand the law and you don't understand how RICO's work. So you are just saying things because you don't know what you're talking about. You think you do what you don't. You don't understand what's happening. Dig? Hold on, man. Give me a second. Okay. Better? Okay, cool. Don't do crime unless you're tough. It's that simple. Don't do crime unless you're tough. If you're not tough, stop doing crime. It's that simple. And that's all I'm saying. If you're not tough, stop doing crime, y'all. Respectfully. If you're not tough, stop doing crime, y'all. It's that simple. That's it. Like I said, you know, that ain't got nothing to do with what I'm talking about. Hold on, man. Ah, man, this is crazy. Hold on. But yeah, man, like I said, like, I don't know, man. Y'all be wildin'. Y'all be wildin'. I don't know what y'all be talking about. Niggas got famous. Niggas made it. Niggas did what a lot of kids wanted to do. They did what a lot of people dreamed of doing. And they still want to play in the street. They still want to be gangsters. They still want to be looked at as mob bosses. And look where they at now. Look where that led them. Look where they at now. You understand what I'm saying? They did all this. They made it. They went big. They went platinum. They won Grammys. And still you want to be in the streets. Now, you know they trying to connect Lil Baby to YSL. They saying the Lil Baby has some ties to YSL because, you know, Lil Baby was involved with Thugger and Gunna very heavily, you know. Especially at one point in time. That's why Lil Baby is continuing to do things for the community now, because he's trying to paint himself in a good light, like he's not that person no more. They also say that Lil Durk and them is causing havoc out there in Atlanta behind the scenes as well. So I don't know. Somebody's definitely snitching though. Let me tell you that. Someone is definitely snitching. And by the way, make sure you get these likes up too. Make sure you get these likes up respectfully. We're going to need to get them likes up. Continue smashing that like button. Salute to the chat. Feel free to send donations if you can. We have been live for almost 4 hours, even though it doesn't feel like it. And the only reason my mic sounds perfect is because of all that crazy shit in the background from their courtroom. Unfortunately, that's the courtroom background. It sounds mighty indicty in there. All those indictments just happen to fuck the mic up, nigga. So here's that. Secondly, listen, these niggas is not beating this. If the Italian mafia ain't beating it, what makes you think they gonna beat it? You know what I'm saying? And they won't be living lovely in the jails neither. You dig? But they saying Little Durk is wilding in ATL behind the scenes, and you know Little Durk is heavily involved with Lil Baby, and Lil Baby is involved with goddamn 3 gangs. The nigga Lil Baby might get indicted 3 times over because Lil Baby has some type of ties to YSL, 4PF, and Rolling 60s Crip, who are all on the documents for the state of Georgia of gangs they want to get off the street. So if you're involved with 3 gangs they looking to take down, you might be getting hit a little bit harder than Thug almost, because, nigga, you involved with 3 gangs, you got ties to 3 gangs, nigga. Listen, 3 gangs is a lot to be involved with, especially in Ricos. You got 4PF, you got Rolling 60s Crip, and you got YSL. So if you got them type of ties, it's nasty. You know what I'm saying? I didn't time you out. If you got timed out, it's because you was wilding. So don't ask me why you got timed out. Just take the time out and keep it pushing, champ. I don't know what to tell you. If you was wilding in the chat, that's why you got timed out. All right? Secondly, like I said, these niggas did all the crimes them niggas said they did. And they've been building a 10-year case. You can play all this pro-black nonsense, but if you keep it in the G, these niggas ain't give a fuck about their community. So what's all this pro-black shit about? You feel me? What's all this pro-black shit about? You know what I mean? What's that about? Because, like I said, you know what I mean? Respectfully, and don't get it twisted, because don't get it. You see, the problem with y'all soft people is y'all hate reality. Y'all hate to hear realness. This ain't the type of channel that's supposed to make you feel good, nigga. You know what I'm saying? I'm gonna make you take time. Don't tell me what to say, nigga. Get out my chat. Go eat the Frank Bites, champ. Go eat Frank Bites. Go get you $1 bag of Frank Bites and get off the channel. You're not gonna tell me what to say, nigga. I don't care how you feel, nigga. This channel ain't supposed to make you feel good. This is not what my channel is for, nigga. This channel was not supposed to massage your feelings, nigga. I don't give a goddamn who you like, nigga. That don't got nothing to do with me. You understand? It don't got nothing to do with me. We talking about reality, real shit. We not talking about shit to make you feel good, nigga. If you don't like it, you could go ahead, champ. But you ain't gonna tell me how to speak on my channel, nigga. Are you crazy? It's my shit. Respectfully. Go take time. All right? Who do you niggas think y'all is, man? Man, send a donation, nigga. You lucky to be here. Be happy you here, nigga. Niggas want to get mad, nigga. I don't give a fuck, nigga. Are you crazy? I could care less. The reality of the situation is these niggas did crime and they're going to serve time for it. They're gonna serve time, nigga. You feel me? If you could comment, you not timed out. You know what I mean? That niggas is crazy. You gotta speak truth to power. Y'all niggas want to hear free Thug, free this. Listen, Thug wanted to be in jail. Thug tried the courts, bro. You're not bigger than the law. You're not bigger than the state, and you damn sure not bigger than the feds if they involved. You know what I'm saying? Why do niggas be mad? You feel me? It's crazy, man. Like I said, you got to be tough to do crime. These niggas is out here, you know, being conspirators to murder, conspiracy to murder. That's not good. People don't like to hear what's real. You know, people don't like to hear what's real, unfortunately. And that's the problem. You know what I'm saying? Some of y'all are just happy to see niggas get locked up, but y'all corny, man. I'm not happy to see nobody get locked up at all. What I'm saying to you is there's niggas who are doing crimes when they don't have to be doing crimes in the first place because they already won. Imagine already winning the game and then begging the goddamn whoever's running the arena to push the score back. Let's go back to the second quarter. Like, come on, bro. That doesn't make sense. You won. You did a lot. You lived the dream. You lived the dream that a lot of people wanted to live, and yet you're still wilding, which makes absolutely no sense. But people will argue you down, talking about, oh, well, they're being targeted. The lyrics, listen, the lyrics matched up to what was in the indictment, and they put it in the indictment. There are plenty songs that they use. And whoever Little Woody is, he snitched. He made it very clear what the words meant in the songs. You know what I'm saying? And they all tied back to the text messages they got from the wiretap. You dig? If you like Frank Bites, this is not the place for you. Maybe you need to go to another channel where Frank Bites are accessible, because on this platform, we don't sell Frank Bites, champ. We sell good content, but we don't sell Frank Bites. Frank Bites, no. You don't get the Frank Bite deliveries or refills here. You might want to take that somewhere else, champ. I'm not going to hold you. You know? Still trying to gangbang, still trying to be mob associated while being famous is insane. You know? Niggas talking about black people this, black people that. Man, niggas don't even care about each other. Niggas don't even give a goddamn about each other. You feel me? I'm not here for it. I'm not here for the race games and all this freedom fighter bullshit. No, nigga. You did crime, champ. You don't have to deal with that. Showface is not a freedom fighter. You understand? Facts are facts. If you know, you know. Niggas, and the niggas ain't hide this shit. Listen, it'd be different if the niggas was hiding it. But these niggas told you what they was doing. It's different. They told you what they was doing. When YFN Lucci's mother got shot at her crib, Thug told you. Thug told you what he was doing. So why are we mad now? Why are we not mad at Thug for doing crime? Oh man, listen. It's nasty. Like I said, this is nasty. This is not good. And look, you also got to realize Young Thug and them was gatekeeping Atlanta. They was gatekeeping and extorting a lot of rappers. Little Uzi got extorted by Young Thug. And Little Uzi is not the only rapper that got extorted by Young Thug in Atlanta. There's plenty of artists who got extorted by Young Thug, and niggas was trying to gatekeep and control niggas and make niggas rep YSL. It was big extortion going on, man. Niggas was gatekeepers and putting pressure on niggas. How was any of that cool? To me, that's not cool, man. You was trying to put mob style. You was trying to put mob style crimes, you know, in Atlanta, in the music scene, and you was literally trying to get everybody to rep that YSL shit. And that's why goddamn Source Walker and them wasn't fucking with YSL. Because you remember Source Walker and Young Thug beef. Them niggas in Houston wasn't jacking that YSL shit. That's why Source Walker was going off on Thug back when he was. You understand? Because them niggas understood what was going on in Atlanta. These niggas was extorting all the new up and coming talent in Atlanta because they could. They was doing it because they could. They wanted to have that type of shit up there, man. That's what they was trying to do. They was trying to extort artists and shit. They was trying to extort artists and shit. That's what they was doing. They was trying to force niggas to be YSL. All types of artists that you don't even know about, they was extorting. You understand? Respectfully. That's what it was. So you can't be mad at if niggas get caught up doing this when niggas was openly admitting it and flexing the fact that they was getting niggas bodied out here. I'm just saying, man. So listen, that's just what it is, man. These niggas was wilding on these Atlanta streets. You know what I mean? These niggas was wilding on these Atlanta streets. What more do you want me to say? You know, you could argue all you want. The fact of the matter is niggas was admitting to what they was doing, man. You dig? Niggas admitted to what they was on, what they was doing. It's gonna get nasty, man. You feel me? Shit's wild. Boy, oh boy. See, and look, you can't even ask me questions because again, you're not in the mix. You don't know nobody in Atlanta. You don't know what's going on. You know what I'm saying? Nigga said, who told me they were extorting rappers? And that's why a lot of you people that's not even from that lifestyle or from the hood could even speak on this because y'all don't understand the concept of extortion. Y'all don't understand the concept of gangs. Y'all don't understand the concept of mob shit. Y'all don't understand that because y'all wasn't around that. Y'all don't know no gangsters. Y'all don't know no mobsters. Y'all don't know people like that. Y'all have no education on street shit. So y'all can't speak on it, unfortunately. You know, a lot of y'all go on YouTube and y'all look at these channels, and a lot of these channels don't even know what they're talking about. They'll tell you about a project that's not even that dangerous being the most dangerous project in a certain area, and they never been to that area. They said one of the projects I grew up right near was one of the most dangerous projects in Queens when it's not. These more dangerous projects. Niggas just be going up here doing little research and think they know the street shit, but they don't. You don't understand the concept because you wasn't around it. You know what I'm saying? You wasn't around it, so how do you even understand the concept of that? You don't get it. You know? Hey, 10-15, you could be from Atlanta or not. You're not, but you're not outside though. I don't care where you're from. You were not outside in Atlanta. In fact, you're probably not even from Atlanta. You could just be saying that. I don't even trust what you're saying because for all I know, you know, you probably, like I said, you probably never even been out there, respectfully. You feel me? So once again, like I said, they was extorting rappers and they did extort rappers. Y'all niggas do not know what y'all talking about. They don't know no behind the scene. They don't know nothing. But yeah, man. A lot of y'all just saying shit because y'all don't understand. Y'all don't understand what's actually going on. And y'all don't understand the concept of what's going on. You know what I'm saying? This shit is a lot deeper than it looks or than it seems. But y'all don't understand the concept of what's going on. You know? Real talk. That's just what it is, fam. That's just what it is. You dig? Who's bothering me? Hold on, somebody messaged me. Somebody messaged me. Hold on. Salute to everybody in the chat though. Make sure y'all smash the like button. We still waiting for the we know the answer. Honestly, we know the answer to, what's going on here. But like I said, we just waiting for the judge to come back and say that he's not going to grant Thug bond, because he's clearly not going to grant Thug bond. And we know this. You know what I'm saying? So Gunna was also denied bond, as we knew which would happen. And they said it. We already knew that people was going to get denied bond. That's just what it was, man. Facts are facts, and he was denied bond. They also tried to extort Rich Homie Quan, and Rich Homie Quan wasn't going for it, because Thug almost tried to smoke Rich Homie Quan, because they was trying to extort Rich Homie Quan into YSL. But according to people, they didn't try to extort any rappers. Okay, copy that. They ain't trying to extort no rappers. Nigga, yo, listen, people extort shit all the time. It's regular shit. It's nasty work, man. That nigga ain't giving nobody bond. The judge not giving nobody bond, bro. Ain't nobody getting bond. Not today, not tomorrow, nothing. Shit going to trial in January. And niggas is gonna get booked for a very long time. They be lucky to not get a life sentence, but at this rate, 20 years is already life. 20 years is already life. Ain't nothing nice about this shit, champs. I'm gonna keep it a G with you. Ain't nothing nice about it. Like I said, y'all think this Rico shit is funny. It's not. This shit is not a game, bro. And when niggas get hit, they gonna get hit, period. So, I don't know who told you otherwise, but I'm telling you what's gonna happen. And I haven't been wrong since. It's a repetitive cycle. I mean, this is kind of this is low-key a first of its kind to a degree, because, like in the Bobby case, when Bobby and them got hit with a Rico, Bobby and Rowdy wasn't the leaders of that shit. They wasn't the shot callers of that shit. They was going for all of the niggas that was putting in that work for real. You know what I'm saying? But yeah, dog. It's nasty. It gets very nasty, champs. I'm going to keep it a G with you. This shit is not pretty, and it's not going to get pretty. I'm telling you, it's not. This shit don't ever get prettier. Very nasty. I mean, we lost some good artists, but these artists wasn't good to their communities at all. These artists wasn't good to their communities, though. I'm going to tell you that. Feel me? Very, very nasty. Very, very nasty indeed. But yeah, man. It gets crazy, like I said. It gets very nasty, man. I guess we waiting for this judge to pull back up. You know what I'm saying? Yeah, they have a Rico in Philly coming. Philly Ricos is on the way. Yeah, coming. They trying to wild out over there in Philly. Yes, they are. You dig? Real talk. It's about to get nasty. Yeah, they trying to wild out. They trying to wild out in Philly. Them Ricos is coming all over. They trying to do Ricos all over the place. This is gang. They about to do the gang enhancement laws like Cali did. But like I said, if niggas want to live that lifestyle, what comes with that lifestyle? You either gonna die or you're gonna get locked up. And I also say this. I don't say this often, but if you want to keep it a G, if Young Thug was released right now, he would literally die. You know that, right? If Young Thug was on the streets right now and they released him, he would die. Why? Because when Thug's baby mother got smoked, that was because all of the real steppers in Atlanta was getting released. They was taken out because the real gangster niggas in Atlanta, like the real deal hitters, was in the feds. They just released a lot of those steppers out the feds because they was going to bring in a lot more of these gang members like YSL in. So in order for them to bring them in, they had to release some of them hitters from the feds. Now, a lot of those hitters was after thugging them. And that's why Young Thug baby mother got smoked. One of them hitters smoked Young Thug's baby mother. That's why Young Thug's baby mother got clipped. So those hitters that they released from those jails in Atlanta is the reason why his baby mother got smoked. Thug would have got smoked by one of them niggas, because them niggas would have went and smoked Thug if he was out right now. So honestly, them keeping him in right now is low-key saving his life to a degree. But yeah, if they release him, he's gonna get clipped. I'm telling you that right now. If they release Thug now, he's gonna get clipped. Them niggas came out on bullshit. They was after Thug. You know what I'm saying? Real talk. Thug would have definitely got smoked by one of them niggas. That's why Thug baby mother got hit. You know what I'm saying? Facts is facts. You dig? Like I said, Thug won't get, nigga, take time. Take time, nigga. You don't even know what you talk about. You're not even from Atlanta. Shut up. Leave, champ. Take time. Why y'all be talking, bro? Why do y'all be talking? I don't know. Niggas don't like to hear that, but that's what happens in gang shit. In gang shit, people get smoked, champ. You know that, right? Who you think was gonna be next after his baby mother? That the baby mother getting smoked was a warning sign. The baby mother getting smoked was a warning sign for Thug. You know that, right? It was, because they would have went after Thug right after. It's a war. It's a war in Atlanta. It's a war in Atlanta. That's what it was. And since he got locked up, there's been a lot more crime in Atlanta. It's not safe out there. You know what I'm saying? It doesn't matter if you're born and raised there. You're not outside, champ. You don't know what's going on. If you from Atlanta, then you would. If you from Atlanta and you outside, then you would know that niggas got released from the feds just to lock these niggas up, and more niggas that they plan on taking off the streets. You're not outside, Mike, twice. If you are from Atlanta, you're not outside, champ. Respectfully, I don't give a damn where you from. You're still not outside because you don't even know what's going on outside, champ. You're staying in the crib and you're doing safe things, champ. Salute to you. It ain't nothing wrong with you not being outside, because it's not a privilege or it's not nothing to celebrate that you're out there. But you don't know anybody out there, champ. You are not tapped in or nothing like that. You feel me? You are a very safe person. You're probably a cop caller. And if that's what you do, that's cool. But you're not outside, my boy. Respectfully, you don't know what you're talking about. You dig? First off, the person that killed, to my knowledge, the person that killed Young Thug's baby mother did not get arrested. Just because you kill somebody doesn't mean you're gonna get caught either. You feel me? I don't ever recall that person getting locked up for doing it. You know what I'm saying? Ah, man. He says I'm outside now. Are you getting fresh air, champ? Mike Twice, are you getting air, champ? You went outside to get air, right, champ? Did the clouds tell you what's going on in these Atlanta streets? Huh? Mike, did the clouds tell you that there's some gangster shit going on outside, champ? Oh, here goes the judge. Is he back? Where he at? No, he ain't back yet. Listen. Yo, Mike, take time, bro. You're lying. You coming up here lying, telling stories. Stop doing it. You want to take, this is not the channel for you, champ. Yeah, outside doesn't mean just chilling outside. This nigga said, I watered my grass today. I was outside. How are you telling me? I watered my grass. I watered my roses. I'm outside, champ. No, you're not, champ. But let's get back to this, please. Let's go. Let's get back to it. Let's get back to it. We're back. We back, champs. Let's get to it.
I've had an opportunity to reconsider the defense's additional pleadings that were filed in this particular case on motion to reconsider bond. It was filed on behalf of Mr. Williams. I have considered those arguments under the new indictment of 22 SC 13572, even though they were filed under indictment 22 SC 182273. And I've considered the proffers made by state. I've considered the arguments of the defense. At this point in time, though, Mr. Adams and Mr. Steele, I am still not convinced that that what you've argued, or what you've continued, or what you argued, anew and taking into account what I have heard already, I still believe that the court, it is the court's decision that the four factors under consideration, that I'm going to deny bond at this point in time.
Yes, champ. I told you, thug and gun.
It's not lost on me that your client's in custody. Not lost on me your client enjoys a presumption of innocence. I respect all of you as seasoned advocates, and I understand fully that there are differences in bond and differences in what may be pled at trial. And I understand that you all as defendants don't have any responsibility at all to present anything, that the government has the responsibility to present and prove everything that's alleged in the indictment and the elements therein to a satisfaction of beyond a reasonable doubt. So that will be decided later, but at this point in time, under Title 17 and under the case law that's been argued thus far, I am not going to grant bond at this point in time. Bond will stand denied. All right, is there anything else I need to kind of go through with you all at this point in time?
First,
Mr. Adams or Mr. Steele, we have proffers. The remaining proffers, I will attempt to try and get those folks here for the 8th of September, who are otherwise unrepresented or maybe in the Department of Corrections. Anything else? Then I understand you all have some motions you're about to file. If you should, for whatever you file, please send courtesy copies to myself and in particular Mr. Kearns and Mr. Chamberlain, so that because we're not an e-file party, the court is not an e-file party, and that's the only way we'll get those. And upon getting those, I will figure out a date and schedule you all for any motions that may need to be heard or issues that I need to take up. Okay. All right. Mr. Geary, anything? Okay, we have dates, and you, Mr. Geary, you owe me, I believe that you have presented orders. I have signed those. Mr. Chamberlain should have given those back to you. You will file those, e-file those for the null process in the case. Yes, sir. Just want to make sure I have the right indictment. Under the old indictment, that would have been 22 SC 182273. And the motions that have been filed on that will be carried over into the new indictment ending in 572. So I'll need that. And we have several matters that will need to be taken up on the 8th of September. Mr. Chamberlain will go ahead and publish or send out notices for that. Mr. Chamberlain, anything else, sir? Yes.
I've been here all day, so I have not got a chance to confirm. But I can send them for all the individuals that I know that are unrepresented and in DOC custody.
Yes. In particular, custodial information. Yeah. And what I will do, Ms. Rosenwasser, if you would go ahead and I know that you all have told me which individuals are not represented, but if you will roll that up, and I think you may have done that while we were sitting here. I'll go ahead and I will go ahead and include all of you on an email. I did receive an email from bear with me. Please bear with me. From Miss Vanessa Carroll, she's an attorney with the Southern Center for Human Rights. People are very interested in this lack of C3 representation. So I will go ahead and send out another email to Miss Bernard and the folk and Miss Ali, and send out something to see if we can get some movement with that. And if it goes much further, I'll have to relook the situation. I may have to ask the county for some funds to appoint counsel to represent folks who are unrepresented. But I'm not going to let it go much longer. So that's still on my radar. All right, anything else? Okay, then everyone, I appreciate your patience. Mr. Adams, I apologize to you again if you felt for any slight I may have given you, and know that all of you are held in high esteem in the criminal justice system in terms of your advocacy and ability as advocates. Okay? Okay, all right. At that, we're in recess, all right? Okay.
This shit over, nigga. Hey, y'all, this shit is over with, basically. So what I want to say is, seeing people mentioning like I was saying. So what I meant to say was, Young Thug's sister losing money had nothing to do with her being broke. The state froze her assets. The feds of the state froze her Cash App, her Venmo, and her PayPal. She cannot receive money at all electronically because the state froze her assets. She cannot access any banking electronically or nothing like that because I guess she was either sending money to Thug or receiving money from Thug, and I guess that, whatever they got going on, they froze her shit. So she can't use Cash App, she can't use Venmo, and she can't use PayPal because, this Thug shit is a part of a RICO, bro. It's that simple. Make sure you smash the like button, subscribe to the channel if you're new, and also salute to all the new subscribers. Okay? Salute to all the new subscribers, etc. You know what I'm saying? Salute to y'all. Make sure y'all smash the like button. I will be live again soon. But salute to y'all, man. Feel free to send donations if you can. But we up out of here, man. Y'all be easy. I'm about to leave y'all with some announcements. Here's a word from the sponsors. Let's pay these bills. I'm up out of here. Y'all be easy. Peace. Then make sure you go to wearetough.com right now and get you that new Sniper Gang merch. Use promo code Showface News to get 15% off on your order right now. And also make sure you follow Showface News on Clubhouse right now to be a part of the conversation. Join the Sniper Gang today. Salute. They're not. These are stats from a personal client of mine who followed all my methods. And look where they at right now. This only took 2 days. This was only 2 days. This ain't take too long. This took dedication. This took hard work. He used YouTube Shorts. What are YouTube Shorts anyway? YouTube Shorts are in a battle with TikTok right now, trying to be the best at this whole quick video thing. You know what I mean? So the competition level is crazy. YouTube versus TikTok is going on right now. So the number one thing being viewed right now on YouTube is these quick YouTube Shorts.
But how do you get in this algorithm of YouTube Shorts to be getting views like this? 306.5K views in 2 days. I'm telling you, my methods work. If you serious about this YouTube thing, just DM me. Let's get you right today. Today.